Okay, we're now live.
Okay, are we going to take the roll?
Yeah, I can go ahead and do that. Bashan? Brynelson?
Present.
Falmouth?
Here.
Fleischman?
Here.
Hamilton?
Here.
Hardston?
Here.
Kirkmeyer?
Here.
McRae?
Here.
Olvera?
Here.
Shining?
Here.
Sarouche? Spiro?
Here.
Torres Ambris? Oh.
I see Fariba there, her hand is up. I think
I
she's
see
stuck.
that. Okay. I see Fariba. Yeah, let me just,
I think audio also. I think she just didn't unmute herself.
okay.
Yes, I am here. Thank you.
Okay, great. And Judge Yu?
Yes, here, good morning, thank you.
Okay, so I think we have everyone but
Is
Sharon.
Fariba still in the attendees?
Yeah, I just promoted her. Let's just see. Okay, great. Okay.
All right. So Amos, did you want to kick us off? We've asked Amos to chair the working group meeting today. Unfortunately, Chris Iglesias's term with the board ended, or it will end November 1. And so I know Donna has been working on securing a new chair for the group, but in the interim, Amos has graciously agreed to chair today's meeting. So do you want to kick us off, Amos? I know we want to take a look at the attendees and get a sense of the number of speakers, but why don't you go ahead and introduce what we're going to be doing this morning?
That sounds great. First, I want to just thank the working groups who have been working since the subcommittees have been working since the last working group meeting. I was one of the people who thought it would be very helpful to know what was happening with proposals related to licensing and regulation before we selected practice groups that might be appropriate in tasks. So a lot of work has happened since the last working group meeting. I also note that in the agenda materials, there were drafts of minutes for last working group meetings. I understand we're gonna start doing minutes more regularly, but since they're not on the agenda, we're not gonna take any action on that. Is that right, Leah?
That's correct.
Okay, so if people have a chance, please review those minutes, but we won't take action today. We'll put it on the agenda for next time. So I'm also very glad that we have an extended public comment period for this meeting. I think it's important that we listen to public comments and consider them carefully. My understanding is we do have an extended time and may spend most of the morning on public comments. So to figure out just time-wise what we can, how many minutes for each comment, I think it would be helpful to get a assessment of who's on the line. I'm not able to do that from my computer screen. Do you have a
Yeah.
Maybe we can have people raise hands if you would like to make public comment, and we can just count it up and see how we can allocate time effectively.
Yeah, that would be good. They're starting to.
And while we're waiting for people to raise their hands, I'm wondering if we should introduce Andrea Fitanides. Andrea is the new director of the Office of Access and Inclusion. She's joining the working group as staff. So welcome, Andrea. And I don't know if you want to say a little bit about yourself and your background.
Thanks, Linda. For those of you I haven't met yet, so Andrea Fitanides, both names of which are challenging to pronounce, and happy to be in the role of the director of the Office of Access and Inclusion, and also being able to support the work of this working group. Most recently, I was pro bono counsel at two large law firms. And prior to that, I was a supervising attorney with the Justice and Diversity Center with the San Francisco Bar. And again, very much looking forward to working with this group in my new role.
Thank you, Andrea, and sorry that I mutilated your name.
Not at all. They're both very tricky.
Okay. It looks like we have 12 people who raised their hands to speak. Oh, now it just dropped. No, 12 people. So.
Okay, that's great. So I think we should jump right into the public comments. And I think if we could give 7 minutes each and a warning when time is wrapping up, and then we can assess after the first 12 people, we can see how many other people want to comment. Does that work?
That works. So
That
I can
sounds
do that.
Okay.
So the first person is Angela Grijalva.
Yes, hello.
Okay.
Angela Grijalva here, and I appreciate this opportunity to contribute. I am a legal document assistant here in Sacramento, California. Apart from that, I do a lot of community work. I volunteer at the food bank, legal clinic, the local domestic violence legal clinics, and other not-for-profit clinics. So I see need firsthand, day in and day out. I'm sure like many of those who work on the front line do. What I see that the need is, or the barrier to access or resources from my firsthand experience is there's no provider out there who is willing to provide these services pro bono. It's an economic issue. And I would say it's from both ends. There's not a lack of compassion within the legal community or profession. It's just an economic issue from a practitioner's perspective, because, you know, I attended a year at Lincoln Law. I mean, that tuition is fairly affordable and you could work through it and potentially graduate debt-free. However, that school doesn't open you up for certain markets of employment. And it's a class. I mean, we have to look at it the way that our society is actually structured. It's a class, race, access issue on both sides. I mean, if we're going to talk about the issue itself, we need to look at it from both sides. And so what I would say is the practitioner doesn't necessarily, if they go to McGeorge, they might have more viable resources, which y'all know. Y'all went to school and you understand the issues in terms of prestige of the schools and access and doors that they open up to. But I mean, a practitioner, let's say, even if there are statutory fees, right, that they can only charge, it's a time value of money issue. They're not going to take on that charge and responsibility and duty to perform for that client when they need to pay their rent. You know, I mean, how are you going to pay your rent? You have to think about it as a business owner, as an economic issue, as a practitioner. So that's what I see from my fellow, you know, peers in the legal industry. So that's why I dedicate, you know, even though I have my business, I dedicate my time at these certain not-for-profits. That's how I give back, because in my own business as an LDA, it's a price point I can't go below, or else I can't keep my doors open, even as an LDA, and I offer reduced prices, right? And that's how I give back, is I make sure as I volunteer, you know, at the local not-for-profits and give my time free for there. And I will tell the clients, hey, if you can't afford me here, that's okay. Meet me over here and I'll do it for you for free. And there are some that I have certain arrangements with certain other organizations where I'm like, if you come from this organization, I'll do it for $50. Come in, we'll do it, bam, 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 pound it out, right? But and that's just an economic perspective from a practitioner. And this is as an LDA practitioner. Think about it as an attorney practitioner who has a lot more overhead, right, in terms of law school, and I'm sure family like I do and all that fun stuff. So that's a barrier that I see in access to justice. The other thing I see here in Sacramento, because we're a little city, we are proliferated with not-for-profit resources. However, getting to the not-for-profit transportation is a barrier. right? Language is a barrier. God help us if there's a volunteer there that speaks the language that the individual's needing, right? And so, you know, just getting to the not-for-profit place is another barrier. But and let's say they go to the courthouse and they get free services, language, access, time. So you're working a minimum wage job at McDonald's, you're on schedule, and you have to explain to your boss, I have to take the day off to work and to attend this workshop, right? Because that's how the local not-for-profits are usually structured, in workshops where you have to come, go through a series of things. That's how they are able to handle large volumes of public, right? Because you can't do it, it's not efficient otherwise. So you have to sit and wait in a workshop and wait for assistance, attend a class, go so on and so forth, submit your documents, right? Filing the documents here in Sacramento County, for example, it's only paper filing. Access to making copies. For, people don't understand, like, especially those who don't have to experience, oh, I need to make a copy, I need to send a fax, because we have a fax machine, right? The littlest things like those are barriers. I mean, making sure you have an original and 2 conforming copies. For, paying the court filing fee for those who don't qualify or don't receive any qualifying benefits, right? And the other issue is, and let's say SAC had electronic filing, access to a computer, internet that's stable. I mean, I've been watching a lot of the Zoom hearings, and people are cutting in and cutting out because they don't even have basic internet. I mean, we see that in our education issues that we're having right now with Corona. Children aren't able to show up and go to school because they don't have internet. How do you expect? I mean, and now it's at issue now, but how do we expect the public to have those? I mean, internet is a basic need, it's a basic need at this point. Internet-based transportation, those are all basic needs to be able to print. And then let's talk about reading and writing,
Ms.
right?
Grijalva, about 30 seconds left.
Okay, thank you. So reading and writing is another issue. One of the issues that I want to share real quick that I find here in Sacramento is a barrier is you cannot go to the self-help and get help if you don't have an ID that they say is fairly recognized. They will not accept the Mexican consular matricula. For whatever reasons, you have to go get the passport. So there's
okay. I'm
systemic
going to have
barriers.
to ask you to stop now. That's your 7 minutes. Thank you very much.
Thank you.
The next person is Steph Carroll. Looks like you're still muted. If you can unmute yourself.
Thank you. Sorry, can you hear me?
Yes.
I appreciate that. Thank you very much for this opportunity to comment. Public Counsel is the nation's largest public interest law firm, specialising in delivering free legal services to low-income communities. Through a pro bono model that leverages the talents and dedication of thousands of attorneys and law student volunteers, last year we provided legal services to over 50,000 people. One of our oldest projects is the project I work in, which is the Consumer Rights and Economic Justice Project. And our mission is to advance economic justice by providing legal counsel for and advocacy on behalf of low-income individuals and their families. Before I comment specifically on the content of the status reports, I wanted to reassert Public Counsel's opposition to the creation of a paraprofessionals programme as currently envisaged. At heart, what this working group is attempting to do is to create a for-profit industry where there doesn't need to be one. Although it has been pointed out in working group meetings that this intended for-profit industry is only meant to serve folks at 400% of the federal poverty level, there is nothing in the reports presented here today that would stop paraprofessionals from targeting the low-income clients that we serve. Where do you think most paraprofessionals will hang out their shingles? We know it will be in the heartlands of our low-income communities. Forgive me, my computer is doing something strange, forgive me. But we know it's going to be in the heart of those low-income communities, targeting our monolingual Spanish-speaking clients and other vulnerable populations such as elders. And also remember, our income guidelines are not nearly as restrictive as you might think. We can serve elders at any income level. For non-elders, the federal poverty level is 12,760 for a one-person household. But our income guidelines allow us to serve people over 3 times that amount. And, you know, in response to the recent speaker, we at Public Council don't work on a workshop model. We work on an intake basis. People call into our hotline or fill something out online to get service. We know our clients, and we know that they often turn to folks in their immediate neighbourhood, and that they often don't know that what they're dealing with is a legal problem, potentially with a legal solution that could take that problem away altogether. The Justice Gap study is, as you should all know by now, deeply flawed. But one of the biggest problems that it did speak to is that most people don't recognise when they have a legal problem, and nothing in the proposals that we have seen addresses that issue. Turning to the reports again, our first overall comment is that these reports talk about building on the key principles identified by ATLS. Can I just point out that the ATLS task force never envisaged that any paraprofessional would be allowed to advocate in court, something that this working group seems to have clung to as a recommendation they want to make, in spite of fierce opposition from legal services groups. And our only axe to grind here is the protection of our low-income clients. Second, we want to protest the fact that these subcommittees have consisted of only 2 persons. The flaws in the system are palpable. Firstly, having 2-person committees sidesteps the requirements of Bagley-Keene, which would have mandated greater transparency and opportunity for public comment. Secondly, having larger groups would have prevented the situation the Regulation Committee found themselves in, with 2 members pulling in very seemingly opposite directions. We're glad to see that at least Mr. Hartson recognised the need for consumer protections to be part of the regulations. With respect to insurance, bonds and security funds, yes, we believe those items are important to help hold bad actors accountable. But as we know, ultimately, those mechanisms only work to help a very thin sliver of complainants. As I've mentioned before, I have yet to see a client benefit from any of those consumer protections available in other areas. The proposed restitution fund, I think, is a better idea, although it is unclear how it will be funded from the start. For some of the remaining topics on the regulation side, I'd note there is no mention of mandatory disclosures that paraprofessionals will be required to tell people that legal services provide free legal services to them if they're below a certain amount of income. There is also no agreement on fee caps, but we see those as essential for consumer protection to make sure our clients are not being ripped off without any work or any work of value being performed. And I believe there's a client and another colleague from Public Council on the line with stories of things that happened to them. As regards licensing, we would advocate for paraprofessionals to work directly under the supervision of an attorney. We urge the working group to take to heart what happened in Washington State, a system with relatively robust licensing requirements, and not use that as a way to sidestep consumer protection. We note that the spokesperson who spoke to the group from that programme admitted that she served folks who could have gotten free help from legal services organisations because of their income level. In addition, we would like to see searchable databases of licensees available to the public, along with a simple complaint system and a publicly accessible complaint database similar to that used by the Federal Consumer Financial Protection Bureau. Finally, I would just like to urge the working group to look beyond the profit model and to also recognise that one of the eventual proposals that you can put before the board is the no-build solution, i.e. go back to the drawing board, taking public consultation from the very start, gathering data to identify the real problems that exist and fashioning solutions that meet them in a way that truly protects low-income consumers. I thank the committee for their time.
The next person is Dean Michael Hunter Schwartz. You want to unmute yourself? Thank you.
Good morning, everybody. I just wanted to thank you all for the important work that you're engaged in, and for the opportunity to share a couple of thoughts. And I certainly do not think I will need the full 7 minutes, although I appreciate the generosity of that offer. So I want to sort of talk about the educational prerequisites right now as it stands. It's a JD or a paralegal degree, And I'm just sort of saying it should make logical sense because, for example, if someone has an LLM degree, is eligible to sit for the California bar exam, it doesn't really make sense that that person would not be able to serve in this role, since that really is somebody who has either a US or foreign law degree plus a US LLM degree. And in a very similar way, I would say that if a paralegal degree would qualify, assuming this person does all the courses they're required to do, certainly the sort of newer degrees offered by law schools, Masters of Science in Law, would make sense as a qualifying degree, assuming they get the courses that are required, because those degrees require the person to already have an undergraduate degree and then go on and get the additional degree. So sort of basic kind of a common sense thing. It makes sense to me that that we make sure that the things that we are allowing to qualify reflect the demands of the profession. And both LLM degrees and Masters of Science and Law degrees are offered exclusively by law schools, are accredited by the Western Association of Schools and Colleges, and the American Bar Association acquiesces in the offering of those degree programs. So we're talking about real degrees with real requirements, with more than enough credit hours to meet the credit hour requirements you've identified. And so I'm just asking you to think about whether it makes sense to exclude those other two degrees from the degrees that qualify for this. And then I guess, aside from that, I do want to endorse some of the comments of the person who spoke immediately before me. I've learned not to repeat others, so I will not repeat any of those points. So I appreciate my time and thank you for the opportunity to share my thoughts.
Thank you. The next person is James Gordon.
Yes, good morning. My name is Jim Gorton, or James Gorton. I am an estate planning and probate attorney. My office is located in Pasadena, California. I've been practicing for approximately 40 years. I've been specializing in estate planning and probate matters for about 25 years. I'm a certified specialist in trust and estate planning. I wanted to address some of the AI aspects of the reforms that are contemplated. How is it that, independent paralegals with, less training and education than a newly admitted attorney are going to be able to supply competent legal advice? And of course, the answer that a lot of proponents in this area have come up with is AI, artificial intelligence. But, how is it that an independent paralegal with, little education and training, very little experience, how are they going to know what to make of the output of AI that they get, or even to recognize if the output of the AI is incorrect? The paralegal won't have a clue, and nor will their unfortunate consumer clients. So I think the question that we ought to be asking is, will the AI providers themselves have any legal liability to the consumers whose lives they damage? Or do they expect that, just as in all other tech enterprises, that they, like Google, Amazon, or Microsoft, will immunize themselves with contracts of adhesion, ensuring that they can't be sued? I think we ought to go, as one commentator I think has urged you to do, to go bold in having laws and regulations which make AI providers equally liable for malpractice with the independent paralegal. If the AI provider is providing the legal advice, then should it not be liable if the legal advice turns out to be wrong, just as any attorney would be liable? I think we ought to make sure that any company providing AI legal services through paralegals will be fully liable. We ought to make sure that makers of AI cannot hide behind contracts of adhesion like Google, Amazon, and all the rest of the tech world do when serving their consumers. And let's also make sure that AI providers cannot hide behind limited liability entities. Attorneys can't. Why should AI providers who are practicing law be able to do so? Let's be sure that the people behind the service being rendered are liable, and let's make sure that in the event of multiple corporate or entity layers, that all AI providers must carry errors and omissions liability insurance proportional to their sales of AI solutions. And finally, I think it's time to think creatively about ethical standards and rules of professional conduct for the AI providers themselves. If they are practicing law, which they will essentially be doing, then, for instance, what constraints will there be on the use or sharing of their customers' personal and privileged information? What rules need to be in place to ensure that traditional client safeguards afforded by the rules of professional conduct are afforded to those who receive legal services through AI? And I don't see that any of these concerns have been even considered in the committee proceedings so far. And I think that it's important that they be considered, because this is to be a major component of making independent paralegals something that is viable. As to paralegals, I think it's of a bit dismaying that the committee so far seem to have relegated or sidelined the question of rules of professional conduct, as though that were something of marginal importance rather than a critical protection for consumers against abuse. And I think the question should be easily settled by just making paralegals subject to the rules of professional conduct already in place for attorneys. These protections have had decades of development, modification, and use, and I think it'd be foolish to ignore this significant body of wisdom and guidance in regulating the delivery of legal services by independent paralegals. We can't ignore the fact that independent paralegals are as human and prone to failure as any other person, attorneys included. We need to make sure that consumers are protected from the bad actors. Thank you.
Thank you. Our next speaker is Kathleen Rivas.
Good morning, and thank you for this opportunity to comment. My name is Kathleen Rivas, and I am a Justice Catalyst Fellow at Public Counsel in the Immigrants' Rights Project. My fellowship project is aimed at combating the pervasive and ongoing issue of notario fraud, or the unauthorized practice of immigration law. While we understand that immigration practice is not a subject area that the working group is proceeding with, we want to bring to your attention the type of issues we have to deal with in the immigration context, where immigration consultants are licensed to operate in a manner similar to the way that this committee is considering allowing paraprofessionals to operate. We at Public Counsel believe that only licensed attorneys should be authorized to provide legal services to the community, especially to those in our community that are most vulnerable to fraud. We think that the rampant fraud that we see with immigration consultants is a warning to the State Bar about the kinds of problems that we expect our low-income clients will have to face if paraprofessionals are allowed to operate in other areas. We are also very concerned that licensing paraprofessionals without proper regulation, consumer protections, and enforcement will disparately impact the immigrant community, which is the same community that is currently being disparately impacted by the pandemic. Many in our immigrant community are frontline essential workers. They are facing extreme health and economic hardships, and this is going to result in an escalation in issues of debt, eviction, and other similar legal issues that's going to cause an increased need for legal assistance. And it's going to drive community members towards those seeking to defraud a vulnerable population. So I want to highlight one immigration consultant, Robert Sirocco of the America's Legal Immigration Foundation, who has been preying on the immigrant community with impunity for over 25 years. Mr. Sirocco is a registered immigration consultant under the ICA and has an active surety bond that is intended to protect consumers and provide incentive for consultants to follow the law. But despite these minimal protections, Mr. Sirocco is well known to authorities for regularly engaging in unethical and fraudulent conduct. Our office is working with a victim of Mr. Sirocco's who sought help from Mr. Sirocco with their immigration case under the false belief that he was an immigration lawyer. And this false belief was perpetuated by Mr. Sirocco himself and his office. Mr. Sirocco, who as an immigration consultant is only authorized to help clients fill out immigration forms and perform other similar administrative tasks, charged our client an exorbitant fee of $11,000 for the false promise of a work permit that Mr. Sirocco said he could get them within 6 months. The only work done on our client's behalf after 10 months was a Freedom of Information Act request. When our client learned that they had been defrauded by Mr. Sirocco, who was not in fact a lawyer, they canceled their deposit and attempted to get out of their contract. Mr. Sirocco is now sending demand letters for over $10,000, threatening to take our client to court and issuing veiled threats about our client's deportation. This type of behavior from immigration consultants, which is behavior that clearly crosses the boundary into the unauthorized practice of law, happens regularly. Clients often think that they're dealing with an immigration lawyer, and the immigration consultant gives faulty, unauthorized legal advice that leaves the client in a worse off position, and in many cases can end up in the client's deportation. Clients pay exorbitant fees for this faulty work, or in many cases for no work done at all on their behalf, and it is virtually impossible for them to recover their money, even for those who are lucky enough to be represented by lawyers who are trying to help them undo the consequences of the fraud. So despite diligent efforts by community lawyers to bring lawsuits against immigration consultants engaged in fraud, for filing complaints with regulatory agencies and advocating on their clients' behalf, most clients never recover the money they lost, and they're left to deal with the devastating consequences resulting from the immigration consultant's work or their lack thereof. So Mr. Sirocco's scheme is just one example out of countless of the harm that regularly befalls immigrant clients when dealing with paraprofessionals. To license paraprofessionals to operate in a similar manner across various practice areas will only exacerbate this problem and fall hardest on those in our community who are already burdened the most because of this pandemic. Thank you for your time and for your consideration of our comments.
Next, we have Lee Farron.
Good morning. My name is Lee Farron. I'm the Director of Litigation and Pro Bono at the Public Law Center. We are a legal services organization in Orange County, and we work with over 1,500 volunteers each year, including attorneys, paralegals, law students, and others to ensure access to justice for our low-income clients. First, I do want to thank the working group for the opportunity for the extended public comment today. I think it will be extremely helpful to get the diversity of opinions and information that we'll all be able to provide. I appreciate that the reports from the 3 working groups were distributed in advance and allowed us to review them so that we're able to provide comment. It's clear there's still a decent amount of work to be done. And I do think it would be helpful to expand those working groups going forward to allow for additional voices to be heard in the meetings, particularly from law enforcement and other regulatory enforcement entities. I do also appreciate that the working group has made this change to focus on the licensing, discipline, and regulation prior to determining the scope of work that would be recommended, assuming that the working group determines that a paraprofessional program is feasible in California. And finally, I appreciate that the working group has stated that the proposed program would be targeted towards people who do not qualify for legal services, i.e. people above, more or less 400% of federal poverty. As one of the prior commenters stated, legal document assistants have to charge at least a certain amount to pay their bills. So no matter what, there's going to be a cost for these services beyond what the clients who qualify for legal services are able to afford. And no matter what, even with the targeted population being the higher income, the middle income, I suppose, we know that our low income clients will still be approached by, targeted, and will end up utilizing these services, even if they're not the intended target of this working group, often because they don't know that they may have access to free legal services. I do have some specific comments on the 3 reports. With respect to the discipline, report, I think one of the biggest pieces that I saw that was missing is what the cost of the disciplinary program would be. I think I'd be interested to know what current state bar staff think would be needed to implement the new system, including the new licensing board, which I would agree with, as well as the additional investigation needed. And then also in terms of the proposal to have some violations be considered minor that might result in a fine or a fee, change versus the major violations. I think that one broad consideration is whether or not those would also become public record, because, one minor violation might not be a big deal, but 20 or 30 or 40 of them, indicates a pattern. And I think there's a lot of kind of work that needs to be done in terms of what information is available to the public. Sometimes even I'm frustrated with how little information we get about attorney misconduct, even through the state bar, and that's of my own profession. So I think that particularly for this proposal, it would make sense to include more information rather than less. Something like a licensee search, like on the state bar website for attorneys, or for licensees on the Bureau of Real Estate, et cetera. And I do think that even minor infractions should be indicated there. Licensing, my question is particularly related to the proposed practical training, which I think is extremely important. I think the question is how that would occur. I would suggest or propose that it would occur under the supervision of an attorney, and that the attorney has to sign off on those practical training hours, and specifically that another paraprofessional wouldn't be able to be the supervisor in terms of those practical training hours. And finally, with respect to regulation, I think this is the biggest piece of it, just because it encompasses so many different components. I think that it is incredibly important that there's a focus on consumer protection, and that those who are victimized by unscrupulous providers will have some measure of relief. I do want to recognize that not all relief is monetary, or not all harm is monetary. And so even with a recovery fund or a bond that might help them get money back, it doesn't necessarily undo the harm that has been caused. But I still think that those are important components. I just don't think it's the only part of it. I appreciate the fact that the group has still a significant amount of work to do, even though they reported that they met 6 times. There's a lot to consider. And it is important to make sure that the individuals who access these services, whether low, whatever population they might be, are protected. I do think that it's that the paraprofessionals don't necessarily need to be treated exactly as an attorney, as was mentioned in the report. They're not an attorney, they're a different licensee. And I think that it is okay for some of the requirements and the regulatory protections to be different as well. And because they're, depending on what all of those regulatory requirements are, I think it is appropriate to provide, to request a higher standard for them. I also think legal services organizations over the last few weeks have met with law enforcement who prosecute unauthorized practice of law cases. And one of the issues that I think is particularly important is there's issues with bad actors within the ranks of licensees, but maybe more burdensome for law enforcement are the prosecutions of bad actors who attempt to hold themselves out as licensees. And that is also something that's particularly important when considering regulation and enforcement. Yeah, I'm not saying that it's more burdensome or less burdensome necessarily, but both of those things are going to come into play. And in closing, I want to reiterate that this proposal is difficult for all of us to grapple with. We recognize that there's a justice gap, and we would appreciate the opportunity to brainstorm ideas to close that justice gap. We also fully recognize that there are competent legal document assistants and paralegals out there. As previously stated, many work for or in collaboration with legal services organizations.
30 seconds left, Ms. Perrin.
Thank you. But we also know that there are bad actors, as there are in every profession. And in these cases, the risk of harm to particularly vulnerable low-income individuals in California, who are also immigrants and people of color, is so great that it requires just a substantial amount of work and consideration before we implement a program like this. Thank you so much.
Okay, thank you. The next speaker is Charlie Gillig.
Good morning. Thank you for this public comment period. It is much appreciated. I'm Vice President at Neighborhood Legal Services of Los Angeles County. We work on a variety of substantive issues for low-income individuals throughout the county. Last year, we represented about 7,000 clients and cases and about 100,000 individuals at our self-help centers. I'm also an adjunct professor at Loyola Law School and teach a class on artificial intelligence and access to justice. I want to start by saying that, I applaud the State Bar for thinking creatively about how to solve these problems, but I would echo the concerns of some of my colleagues that we're moving too fast with the working group. I think these are complicated issues that require more research and deliberation that could produce any kind of effective program. As a starting point, I would encourage the working group to propose further study as to whether this is the best and most cost-effective program to reduce the justice gap. I also would like to echo the concerns about the closed door subcommittee meetings, as it hasn't allowed the public to fully contribute to the discussion until this point. And of course, we only had the very substantial documents to review a few days in advance of this meeting. At NLSLA, we agree that that if the State Bar intends to create a new professional group to address the justice gap, that it also needs to implement a comparable regulatory system to ensure that consumers are protected. However, the proposals before us today fail in two critical ways: scope of representation and funding. We can't analyze whether the licensure, discipline, and regulation systems are sufficient without understanding the scope of representation that paraprofessionals would be permitted to provide. It's my assumption that they'd be permitted across all scope of representation based on these documents, but based on our experience, we strongly believe that any program should not include representation in court. We are familiar with the severe consequences that can arise when a client seeks assistance from someone who's not qualified to provide that assistance and not adequately prepared to represent individuals in high stakes environments. Based on the licensure proposal, I don't think there is a strong indication that paraprofessionals would be prepared for those environments. In regards to the funding, this is going to be expensive to implement a sufficient system of regulation, discipline, and licensure to ensure consumer protection. The State Bar, struggles at times with backlogs in its complaint discipline systems, and we fear that legal consumers, especially vulnerable low-income consumers, are going to be taken advantage of by predatory actors without recourse. We see these predatory practices with attorneys, and we think it's insufficient to merely duplicate or expand that system to a new professional category. So without assurances that it's going to be sufficiently funded, I think we can't be having a lot of the discussions that we're having. If the proffered objective of this group is to provide more access to legal services that are affordable to low and middle income Californians, we think the State Bar should first consider other proven alternatives that do not require the creation of a new professional category. If this working group does eventually propose a budget, we would urge the working group and the State Bar to first consider the benefits of allocating those funds to other sources that will meet the objective of greater access to justice. We would recommend further study as to the costs and benefits of this program and other alternatives prior to approving anything. Thank you again for your time.
The next speaker is Jessica Vapnek.
Yeah, hello, thank you very much. My name is Jessica Vapnek, and I work at UC Hastings, just down the road from some of you. I'm really pleased to be here. Thank you for your time. I was glad to see that there's an educator on this group, and I was also glad to hear from Dean Schwartz, who I didn't know was going to be on this call, who made one of my points, so now I don't have to make the same point, but I do want to add a couple of things. One of the things I wanted to say was about these non-lawyer master programs, which is what Dean Schwartz mentioned. By 2019, there were more than 750 non-JD programs that had received ABA acquiescence. And again, by 2019, 25% of all law schools had such a non-lawyer master program. Over the preceding 6 years, non-JD enrollment was up 66%, and online education was up 231%, and that was even before COVID-19. The programs have different names. Ours happens to be called MSL, Master of Studies in Law. Given what Dean Schwartz said, I think, as I know from Pacific McGeorge, it's MLS, Master of Legal Studies. Other law schools call it an MJur, Master of Jurisprudence, or a Juris Master. But the point of all of them is they're designed to provide training in legal analysis and to democratize legal education. Some of the programs have been around for a while, but there are also a lot of new ones, including in California. And so who are these students? Some of them are lifelong learners, some are career advancers, career changers, post-undergrads. Some have advanced degrees, PhD. We have one this year who has a PhD in biology. Others have an MS or an MBA, some without. They have varied ages, varied nationalities, and varied interests. We have a nurse, we've had doctors, so we have interest in health, business, social justice, tax, employment, engineering, criminal law. And I want to build on what Dean Schwartz said. Not only should these degree holders qualify, but to me, they also bring a richness of diversity and perspectives to serve consumers in California. In terms of access to justice, what I've noticed, I've been involved in our MSL program now for 2 years. There's actually a very high proportion of these students who are minorities. Many can't afford to get a JD. They can't afford 3 years of school or tuition. And so they get an MSL or an MLS. And I do believe they have a role to play in providing access to justice if it's regulated. So to me, a couple of other points I wanted to make. The role of the state bar is it to serve lawyers or is it to serve the people of California? I think if it's the latter, then broadening the scope of who can serve the public helps. When I spoke to Linda Katz earlier about coming to this meeting, I mentioned an analogy, which is that I used to work in agriculture. I was a lawyer with the UN, and I worked in a bunch of different countries around the world. And I remember distinctly in Rwanda, where there was legislation being proposed to allow para-veterinarians to do certain things. And you had I think there were maybe 15 veterinarians in the entire country, and they all wanted to live in the capital city. So there was really no one to serve the public and the farmers out in the rural areas. And the problem is treating it like a guild and saying that, only lawyers can do this thing or that thing. The sky is falling, the sky is falling. But in my own personal view, and I should have said this from the beginning, these are my personal views, courageous regulators can go forward anyway, and it ends up being positive for the population. In Rwanda, when you allowed paraveterinarians to do things like give vaccines to animals, then you ended up reducing the outbreaks of animal diseases. Now, it was important to hear from the earlier speaker about the immigration area and the vulnerability to fraud. So one argument might be that it's precisely by regulating this area that the state bar can play an important role. And then another area I wanted to raise is that in the area of domestic violence, that many states do have exceptions to their UPL rules, the unauthorized practice of law rules, because of the importance of getting advice about laws and the legal system to battered women. And then 2 final points. All the people who spend hundreds of thousands of dollars to get a law degree in California and then they don't pass the bar, are they perhaps another group who we might want to consider? Might they contribute to serving the population of California? And then finally, just to reiterate my main point, which is that there are several schools in California with these master's programs, and it's a growth area. And so we're very grateful to be at the table. And I want to thank the working group again for having a public comment period and for taking the time to listen to my remarks today. So thank you.
Thank you. Our next speaker is Tom Gordon.
Hi, thank you. My name is Tom Gordon. I'm the Executive Director of Responsive Law, which is a national advocacy organization working on behalf of consumers of legal services to make the civil justice system more affordable and accessible. The need for affordable legal help is great. It's far greater than just the population served by legal aid. In fact, most lawyers will tell you they can't afford their own services. So I'd like to start with a personal example, actually, of the need for independent paraprofessionals to provide legal help. I got divorced many years ago, and my ex and I decided to go without lawyers. We used online document preparation services to help us. It was an uncontested divorce. It was very amicable. We agreed on everything of substance. In addition, we were both lawyers and making enough money that if we really wanted to hire a lawyer, we could have. We certainly knew enough about the legal system, though, that we thought we probably could do it ourselves, but we also wished we could have had just a little bit of help understanding some of the nuances of Virginia divorce law and walking us through the process and ensuring that our documents were completed and filed and served properly, which frankly is not something that as lawyers we're particularly well trained to do, especially if you're not a litigator. So, we remember remarking at the time that saying, hey, it would be really great if there were someone who wasn't a lawyer who we could afford or choose to pay for, instead of paying thousands of dollars for legal help and legal representation, that we could pay a couple $100, $300 to have someone walk us through this process. Didn't happen. Divorce went through okay, but we were worried about it for a long time. We just wanted to make sure everything was being done right at what was really a stressful time, even under the best of circumstances. So this legal need extends, like I said, from not just the legal aid population, but the wider population. The Justice Gap study outlines this need very clearly. Only 32% of Californians seek legal help for their legal problems. And of those that didn't seek help, nearly half of them are likely to have cost as one of the reasons for not seeking that help. There's 16% of people that stated outright that they had concerns about cost. There's another 31% that said they decided to deal with the problem without help. Which doesn't really answer the question so much as restates it. They said, why didn't you get legal help? We decided not to have any. So if you asked a parent why they didn't go to an orthodontist to get their child's teeth straightened, and they said, well, we decided to deal with it without an orthodontist, it's possible they didn't think their kids' teeth were so crooked, but it's more likely they just couldn't afford to get their kid braces. So again, combining these two groups, you end up with about half of the people who didn't get legal help deciding that that cost very well may have been a factor. So, another way to look at this, we're looking at a situation where we're requiring everybody to have the maximum possible level of service and pay for it accordingly. So imagine that the state of California decided to pass a law that the only legal method of transportation is automobiles. They decide that it's safer to use an automobile than public transportation because of COVID, and it's safer than bikes and motorcycles because those are more dangerous in a crash. And those are both true. Those are legitimate public safety concerns. But the fact remains that most people can't afford a car. And even those that can afford one, have the money in their bank account to make a monthly payment, they might prefer not to spend the money on that. And they have other needs that they also want to meet. There also are non-monetary advantages to other modes of transportation. You might prefer a bike for exercise. It might be a quicker commute. It might be easier parking. And similarly, in the legal profession and in legal services, the current regulations require everyone to use a lawyer or nothing at all. You have no choice other than the highest priced option, even if that lower priced option may have certain benefits. It might be easier to find that other professional. They might have higher quality of service. One of the notable things that happened in the UK when they allowed non-lawyers to write wills is that they found that they did so with equal quality in a blind study, and that consumers reported higher customer satisfaction with the non-lawyer will writers compared to the lawyers. I do want to note that I'm very pleased that the recommendations from the committee have seen for licensing have shown closer to the Ontario model than to the Washington State model. The Washington program's requirements for education and experience made it almost as expensive and time consuming as getting a JD. So it was no surprise that the total number of licensees was only in around the dozens. And in contrast, the Ontario program, with a more reasonable set of requirements, licensed over 1,000 paralegals last year alone compared to 2,400 lawyers in the province. And having enough providers to meet public demand is going to be crucial to the success of a paraprofessional program. And I'm pleased to see that California seems to be headed in the right direction here. Finally, note about governance. I hope that there will be significant public representation on any governing board, be it for regulation or licensing or discipline. Not just that it be lawyer dominated, but that there be public members and that the non-public members be at least divided so that there's significant representation from lawyers and from paraprofessionals. This is, of course, similar to how the State Bar of California's Board of Trustees has significant public participation, and it's very important from an antitrust perspective that the board not be controlled by members of an industry. It's even more important when that industry is represented not by the service providers being regulated, but by a competing segment of service providers. So again, I'd like to thank the committee for moving this far in the right direction. Hope that it will continue its good work going forward. Thank you.
Thank you. Our next speaker is Christina Toussaint.
Sorry. Can you hear me now? Yes. Yes, great. Okay, thank you. I wasn't sure I was unmuted. Hi, thanks for giving me this opportunity to speak. I wanted to first start by saying I'm speaking on my own behalf and not on behalf of any organization or entity. So again, just wanted to be clear, none of my statements should be attributed to my employer. But I felt this was an important issue to speak on. So I'm an attorney. I've been a consumer protection prosecutor for the last 22 years on both the state, federal, and local levels. I've worked for the California Attorney General, FTC, and currently supervise the LA City Attorney's Consumer and Workplace Protection Unit. During that time, I've worked with victims of consumers at all levels and have seen the devastation consumers suffer when they interact with unscrupulous individuals who've tried to take advantage of them in all different industry areas. We've heard about the immigration consultant victims. I've been involved in a number of those cases. I've seen victims of individuals who are giving legal advice who are not licensed, victims of other unlicensed providers, including doctors, dentists, and others, holding themselves out to be qualified to give advice and information that they're unqualified to give. And consumers in these circumstances don't just lose money that they can't afford to lose, but they often lose much more. In some cases, immigration cases, of course, their liberty, family law issues. You can see, of course, issues with losing custody. In our cases, we've seen a series of very serious issues of people, health issues and other things that come with that. I've seen the benefits that have been offered by legal aid groups, like Legal Aid itself, Betzetic, and others, who really do help consumers who are in these low-income groups who need direct individual representation. And I think these groups offer amazing services from qualified lawyers, and think there would be a benefit of really moving towards expanding those types of services, funding those projects, so that more people can have access to assistance from real lawyers or lawyers supervising others, than going to a completely new system where we are allowing people with very limited experience in this area, even with the training requirements listed, to be able to have a lot of exposure and a lot of ability to influence people's legal rights in a way that could be very serious and very detrimental. I remain concerned that people who are trained in this very limited way will end up charging consumers amounts that are uncapped fees, and consumers may end up paying a significant amount of money. I will say anecdotally, in my experience, despite a number of individuals being unlicensed or unexperienced, they do tend to charge our victims pretty high fees for immigration consulting work, for even the unlicensed practice of medicine, unlicensed practice of dentistry. You would be surprised at what the prices people end up paying, because these are people in their community. They feel like this is their option, and they'll go see these people because they don't have other means, and end up paying a lot of money for really bad services. And with uncapped fees, I worry that this will be exactly what happens. People go thinking they're going to be able to get some help. They ask for an initial small fee, ask for more fees over time, end up either not providing services or providing services that are not of a quality that will assist a person, or in some cases end up harming them very significantly. One of the first cases that I tried when I was at the Attorney General's office was one where we had sales agents going out to seniors' homes and selling them living trusts and annuities. These were not licensed sales agents. They were not attorneys. There was one attorney who was signing off on the trust in that case. And basically there were a lot of seniors who were significantly harmed. We won that case at trial and got restitution for victims, but that obviously is a large action that a law enforcement agency had to take. And I worry about people going and taking advantage of seniors, talking them into making changes to wills when they may not be able to or competent to do so. You could see people going to nursing homes, people working with caregivers, people who already take advantage of seniors in difficult situations could use this as a way to say, you can't prosecute me for unlicensed practice of law because I jumped through these hoops. Therefore, you know, I was giving them advice and now you need to try to prove some sort of misconduct, which again, I am unclear exactly how the prosecutions would work of these cases based on the information I've seen thus far. So I'd like to turn quickly to that, which is in order for prosecutors to be able to prosecute cases, there needs to be a very clear and bright line as to what the unlawful practices are and how those can be prosecuted. I'm concerned, and again, I haven't had a chance to read every proposal in great detail, but that I don't really see what those bright lines are. I'm not really clear as to what the limitations are, as to what these individuals would be allowed to do, not do. Not sure how the investigative process would work to be able to put a case together. I saw there was discussion of sort of a 3-person panel. I'm not clear what authority that panel would have. It would seem to give these people a real advantage over others who might be engaged in the unauthorized practice of law, for whom a misdemeanor is something that is available to us, and particularly in these bad cases. And misdemeanors, courts can also order restitution to victims, and we have other remedies. It seems like these people, by following these limited number of procedures, would take themselves potentially out of that ability to be prosecuted. I'm also unclear about resources that have been dedicated or would be dedicated to the investigation of these matters. I think it would have to be a very significant number of resources. It already is very challenging. I think the bar and others have limited resources for investigation of these kinds of unauthorized practice of law cases. And I think personally, again, not speaking on behalf of the office, these can be quite serious. And I do really worry about what's going to happen to these victims. And if you've got people who are seniors, limited English speakers, or others who've sought this access to justice, when it doesn't go right, how is that going to be resolved? What's the time frame for that? The bonding requirements should not be lower than that of an immigration consultant. These are really serious situations where people can lose a lot of money. What is a process for making a claim on a bond? What is a process for getting redress for those consumers? Would there be something like a seller of travel program where they have a process where people can make claims on that? And how long would people have to wait to get their money back? I mean, people are in desperate straits when they need this help. And a lot of cases we see people take money and don't do services. So
Well, seconds left, thanks.
I'm sorry?
30 seconds left.
Okay, thank you. So I also would advocate for a fee cap. I would advocate for a limited number of practice areas. I generally oppose the idea, but if it is going to go through, I think a lot more work needs to be done on limiting what the areas are going to be, looking at what the oversight is, clearly defining what people are allowed to do, and having a real understanding that people can be harmed very significantly, and it may be very difficult to get redress for them. And I do worry a whole industry will pop up to victimize consumers, particularly the most vulnerable. So I do worry, and I ask for much more consideration before this goes through, and to reconsider maybe advocating for people like Legal Aid to have more resources to be able to help people who are experienced in that way.
Okay, thank you.
Okay, am I next?
Yes.
Oh, okay, thank you. Hi, I'm sorry, my name is Marissa. I actually speak up as a public voice. I notice a lot of people in here have legal experience, and I can understand your concern when you're stating that you have a lot that you want to hold back, and making sure that people aren't taking advantage of anyone or any low-income people who are looking for services. And I really, truly empathize with that, because I've been on the other side of the totem pole where I've been taken advantage of by the legal system. And I'm not saying that that has to do specifically with anyone that's in this group, or that it's something that happens on a regular basis, but I have the background of going through domestic violence, pretty much being on the run for this last 7 years. I paid for legal services, and I had got that attorney because my soon-to-be ex-husband had filed an emergency hearing with the court, and he had my children taken from me. So when I filed with the attorney, it pretty much went through a long run around that I didn't have them. I had to go through visitations. He took nothing into what I had to say into consideration. Following that matter, I was finally able to have visitations with my children, and I saw that my son had a welt mark on his back, a really bad welt mark. I did what I thought was right, and I took him to the hospital to report it. all my ex-husband had to say was, nope, she did it, and my kids are taken away for 2 years. So those are the first experiences I've had with any kind of legal representation. On top of that, my attorney that I had who represented me, she didn't make me feel like there's anything that I had to say that mattered to her or would make a difference. So those are my first experiences. From there, I had law enforcement pretty much turning their back and saying, well, you know, you just have to stay away or file a restraining order. And I tried to do a lot of that on my own, and it was pretty difficult. So from my perspective, I've been around many other people who've experienced that as well. And it wasn't up until recently that I started looking into more legal rights. For the first time, I was able to get a restraining order for myself. For the first time, I was able to stand up for myself when I had my employer who didn't want to pay my unpaid overtime wages. I spoke with about 5 different attorneys who said that they wouldn't take on my case because my employer classified me as a contractor. I already have the labor board who's willing to work with me because of the information that I provided. Sorry, I'm losing my voice. I have my landlord who wanted to go ahead and evict me. She sent a second notice for eviction because of the whole coronavirus stuff. She found a loophole behind that. But again, I found legal rights after extensive research. So my biggest concern is I feel like I really do appreciate what this board is doing, because it does open up a new brand or a new option where people like me can be heard. And I'm not alone. There's tons of people who go through this stuff. They go through domestic violence, they go through child abuse, they go through CPS cases, and they go through employers abusing your hard work. And there's not really too much to turn to. And I am very big on online research, and a lot of the information is not easy to be found. I actually found one website that was very great. He did a great job in explaining the laws. He attached the penal codes. It was beautiful, but nothing like that is out there. There's different blogs like NOLO, and then it gives you a little pop-up and you start getting spammed by a bunch of people who end up saying that they can't take on your case. So I'm not going to use up the whole 7 minutes, but that's just my background and what I've been through. And from what I'm noticing on here, a lot of the people who are expressing their concerns are people who already are in the industry. People who are in my shoes don't even know where to go to speak up. So I hope that my voice can mean something in this public comment. Thank you for your time.
Thank you. Linda, are we permitting James
I'm
Sandman?
sorry, James Sandman is the next person.
Yes, thank you very much. I'm Jim Sandman. I'm President Emeritus of the Legal Services Corporation, which is the country's largest funder of civil legal aid programs. I was president of LSC from 2011 until earlier this year. As you probably know, LSC funds 11 legal services programs in California that among them serve the entire state. I strongly support the idea of providing licensed, regulated paraprofessionals to provide legal assistance to people who currently have no help at all. I want to focus on 2 things. First, what I see in the California Justice Gap study, which was modeled on a study that LSC did in 2017, except it covered all income levels, whereas the LSC studied only low-income people. Second, I want to explain why I think that authorizing more helpers can address both aspects of the justice gap as identified in that study. That is the knowledge gap, service gap. First, I think the statistics in the report show persistent, chronic, very significant unmet legal needs. 85% of Californians receive no or inadequate legal help for their civil legal problems. Among the population eligible for assistance at legal aid organizations, and focusing only on the component at or below 125% of the federal poverty guideline, the study showed that 63 to 70% of that population received inadequate assistance. Only 30% of their problems were fully served. I did not see in the report how many people who sought legal aid received no help of any kind. but I can give you the statistics nationally on what LSC saw in its study. What it showed in 2017 was that of those people who were financially eligible and otherwise qualified for legal aid and an LSC funded legal aid program, 41% got turned away with no help of any kind. LSC redid that study last year in 2019, and the percentage had kicked up to 42% receiving no help of any kind. And these people are just a subset of the population in need. These are people who self-identified their problem as a legal problem, knew where to go to help, and made it through the intake process. Most concerning to me are the figures on the percentages of unrepresented litigants in our courts today. The California Justice Gap study reported that 90% of tenants in eviction cases don't have a lawyer, and reported that in 70% of family law cases, one or both parties is out without representation. That's consistent with figures from the National Center for State Courts, which estimates that in 76% of all cases in state courts in the United States today, one or both parties does not have a lawyer. And that figure, 76%, does not include family law cases. If it did, the percentage would be even higher. I think this is a powerful showing of unmet need for legal services. I think what it demonstrates is that we need more helpers. We don't have adequate assistance that is meaningfully available to people. We've let the perfect become the enemy of the good. By insisting that only a member of the bar can provide legal assistance, we've consigned those who cannot access a lawyer for whatever reason to no help of any kind. I don't think that serves the public. I don't think that protects the public. I think that the concerns that many have expressed about a new licensed physician can be addressed by reasonable, appropriate regulation that addresses the subject matter areas within which they can practice, the permissible scope of services they can provide, education and training requirements, CLE requirements, malpractice insurance requirements, being subject to discipline. And I think that such a position could address, as I said, both aspects of the justice gap, the knowledge gap, and the service gap. The California study reported that many people don't self-identify their problems as legal problems. That's completely understandable. All they know is they have a problem. If licensed paraprofessionals were embedded in the organizations and the places that people go for help when they have a problem, whether it's a social service agency, a public library, a healthcare clinic, their faith community, they could help people identify the legal components of their problem and either help them themselves or refer them to those, to others who can help them. In terms of service delivery, these people could be embedded in legal organizations, allowing lawyers to leverage themselves, freeing lawyers up to practice at what's called the top of their licenses, to address the matters that only lawyers can and should be addressing, the complicated, complex matters. The analogy to healthcare is exactly right, where there's a differentiation of providers with physician's assistants and licensed practical nurses and registered nurses and phlebotomists, which enhances the delivery of service to people and certainly addresses cost concerns. So I think there are ways to address all of the concerns that I've heard expressed on this call. I think that it's critical, urgent, to address the magnitude of the unmet legal need. And I have one final request and suggestion. I think it's critically important to provide a meaningful opportunity for broad public input into this process, like the speaker we just heard from. It shouldn't be just lawyers who are speaking up about what the public needs and what is necessary to protect the public. The public are perfectly capable of speaking up for themselves and need to be heard directly. Utah and Arizona saw this in the processes they went through recently to approve new licensed positions. And the statistics were very interesting. The public supported change by about the same percentage that attorneys opposed it. I think there's a lesson there. Arizona actually had a great,
thank you.
Arizona provided a great roadmap in how to do this, how to reach out to the public. It can be done. We shouldn't be depending on lawyers alone to speak for the public. Thank you for allowing me to speak.
Thank you. Our next speaker is Helen Bellamy.
Helen, you're still on mute. Are you able to unmute yourself? No. Do you want to go to Jenna, Linda, and then come back to Helen?
Sure. Jenna Miara.
Good morning, everyone. My name is Jenna Myra. I work at Betsedic Legal Services in Los Angeles. We provide a range of free legal services, mostly to residents of LA County who are low and moderate income, although many of our projects and programs do not actually have income limitations. Like others have said, I appreciate the opportunity for public comment, particularly expanded public comment, and I appreciate the thoroughness of the status reports that the sub-working groups provided. I think it's put us in a much better place to actually have a constructive conversation about all of these important issues. I want to start with Mr. Sandman. I was glad to hear him on this call. He certainly brings a lot of experience and expertise to the issue. I don't disagree with almost anything he said. I certainly agree with the urgency of the problem, the scope of the unmet legal need, particularly among low-income low-income communities. I do fundamentally disagree, though, that this for-profit model and the way in which this committee thus far has been leaning is a solution to most of those problems. You know, Mr. Sandman mentions one of my favorite ideas, which is embedding paraprofessionals, legal navigators in organizations, community organizations, and legal services organizations. That is a wonderful idea. That has nothing to do with anything I've heard this working group consider. And it's hard for me to see how that would work with a for-profit model. We don't need a new category of paraprofessional licensees to embed legal navigators in community organizations. We don't need new licensees to employ paraprofessionals at legal services. We do that all the time. They are supervised by attorneys, they work with attorneys, and they provide wonderful service. So I don't disagree with Mr. Sandman's analysis of the problems. I have trouble connecting this solution as it's currently being discussed with those problems. And I think that's something that this group has struggled with all along. I think we're coming closer to a place where we're really understanding and being transparent about the solutions and how they match up with the problems, but I don't think we're there yet. In terms of the specific topic of this meeting, licensing, regulation, and discipline, I don't want to repeat everything my colleagues have said. I just want to highlight a couple of points that felt most important to me. One is I absolutely think that we should expand the size of the sub-working groups so that there's more perspectives, more input, and logistically, you know, the ability to have a tie break if necessary, since it seemed like particularly the regulation committee had trouble coming to agreement on much of anything. In terms of discipline, I think it's essential that there be public access to all complaints, even those that are considered minor, and that there be a simple, publicly available, and easily accessible complaint program. I also think we need to think carefully about the cost of all the discipline and the new licensing board. In terms of the licensing, I think at a minimum, the paraprofessional training should happen under the supervision of an attorney. I would encourage the working group to look carefully at the great report that just came out of Minnesota, which is implementing its own version of a paraprofessional program under the supervision of attorneys and limited to just a few areas of law. So I think the Minnesota report is really worth looking at. In terms of regulation, that group made a lot of progress, but still has a lot of work to do. I think it's particularly important to focus on proactive regulation for all the reasons stated in the report. I think there should be audits of things like advertising by paraprofessionals, the disclosures paraprofessionals are giving. I think there should be a disclosure about the availability of free legal services that's required. There should be affirmative checking to see that folks are bonded and have insurance and all of that, that they're contributing to the restitution fund as they should be. I think fee caps are a really good and essential idea. Otherwise, as other speakers have mentioned, the fees drift very close to attorneys' fees. And then we're not really getting the benefits that we're looking for. I think it's absolutely critical that we consider the collateral impacts a new license program like this will have on law enforcement. As Ms. Toussaint made clear, those prosecutor offices are already overburdened, and this would open up a whole new category of investigations and prosecutions they'd be expected to carry out. The very first speaker today made a lot of interesting points. She's a licensed document assistant, and she spent a long time talking about the obstacles to access to justice. And I also agree with much of that. She talks about internet access, computer access, language access. None of those are things that are addressed by licensing paraprofessionals. So I would encourage this working group again to really think about problems and matching the solutions with those problems. And I'll just, end by saying I want this committee to really carefully consider the no build model that's been expressed by some other folks. The idea that after thinking about this some more, this group can and I think should come down with the recommendation that paraprofessionals of this sort, of this for-profit model, are not the way to go. If the working group does decide to move forward with recommending paraprofessionals, I would encourage you to continue the hard work you've started on the discipline, licensing, and regulation front. I think really careful recommendations on all of those topics paired with very narrow areas of law and tasks within areas of law will be essential to make sure that any program does the good that I know this group is hoping to accomplish without any of the unintended consequences that we've heard so much about today. So I thank you for your work. I hope you continue to do it. And I thank you for the expanded opportunity for those of us to comment. And I also appreciated Mr. Sandman's suggestion that members of the public be involved and to look at ways to do that. I mean, these meetings are long and they're during the workday.
Thank you. I want to wrap up.
These meetings are long and they're during the workday, and I'm not sure just putting out a general call for members of the public to join in on these types of meetings is really the way to get the kind of public input that you're looking for. So I would encourage you to think of kind of creative and practical ways to make that happen. Thank you all for your time.
Thank you. We have Helen Bellamy again. I'm going to try again.
Thank you so much. I lost connection. Let's blame AT&T. Thank you. I'm a little shaken because I couldn't believe that I waited all this time and then we lost connection. So I just wanted to remind the committee, first, thank you. I've spoken before. The First Amendment to the Constitution says Congress shall make no law. I understand Congress. And it says, and to petition the government for a redress of grievance. That's what we as the legal consumer has a right to do. Any impediment that is put in front of the legal consumer is an affront to their First Amendment right. I am a legal consumer first and foremost. I will not go into a lot of details, but I actually hear buzzwords that are going on within the committee. Low income. Does low income mean uneducated? Does low income mean vulnerable? Does low income mean people of color? If that is the issue, then we are already in trouble, because that means this committee, as well as, quote, the powers that be, understand who's being taken advantage of. I come to the table saying that low income does not equal that. Everyone in that category is not uneducated, is not vulnerable, and are not people of color. I also come to the table asking you that there are some structural issues that are at stake right now. The fact that you have you have an industry as one of the speakers already said, that is self-perpetuating. That's a structural problem that the legal consumer is up against. When you go to the court and the first sign that you see says, we cannot give you legal advice, that's a problem. I'm asking the question, what constitutes legal advice? Education is not legal advice. I am a tax preparer. And as a tax preparer, because the federal government and the state government requires all of us to pay taxes, that means tax information is free. It's everywhere because there is an expectation. What is going on, in my opinion, and it is my opinion, but it's fact, is that if you hide the ball, no one can find it. So I am truly asking with passion that we open this up. There are bad actors everywhere, but the fact that we're saying that we cannot open this up because you finish it is the problem. Open it up so that the legal consumer can have choice, can have a choice. But if there are no choices, and if only a certain people can provide services or find information, what's wrong with this picture? I am very passionate about this, and it is because I am that person who needed services and couldn't afford it. And the only place I could, every place I went, I saw, find an attorney. Well, duh. What am I supposed to do? That's not right. And I think that, and I just really hope that at some point we come to this understanding that you have to allow people to make their own choice. Free is not free. Free costs. Don't enable people. Allow people to grow. That's what America is about. Why are we hiding the ball? If we knew about the law, then we would understand how to actually use the law. But if the law is hidden from us, I hope you agree that the law is hidden. When you cannot read the law, when you can't find it, when you can't access it, that's hiding the ball. And I come to the table again saying that we have to give the American citizen the opportunity. That's what this country is about. And we have a right to it. And no one has a right to keep it from us. The legal profession cannot be the only people who can access the law. Thank you.
Thank you. Linda, can I just check in on timing? Because I think we're now about an hour and a half into the meeting and we did about 14 speakers. How many public speakers do we have?
We have 3 left, including one who's spoken at the beginning.
Oh, Linda, I think you went to mute.
Sorry, we have 4 people actually.
Okay.
But I want to skip over the person who spoke at the beginning and let give other people a chance to talk, and then we'll come to that person last. Okay?
That sounds great.
Okay, we have Juliana Lee. You want to?
Hi, thank you for holding this public hearing. My name is Juliana Lee. I'm from the Legal Aid Foundation of Los Angeles. My background is primarily in family law and domestic violence, and I also do some immigration work. Just as others have said, I agree that there are many people in need of legal services who are not receiving them. Agree that it would be much better if there were legal services available. We see people who fall into these groups in our work every day. Our clients face the legal system. They face opponents in court who are represented on the other side, and in many ways have never played on an even playing field. So I don't think that at least my concerns about the Paraprofessionals project is not to at all kind of undermine any of those needs, those concerns, and the urgency of that. And I've heard that that we shouldn't let the perfect become the enemy of the good. But here, the good benefits people who have the resources to bridge the gap that remains. And that's a group that by and large does not include our client community. So specifically in speaking about domestic violence, because I know that issue has come up in the comments, domestic violence cuts across huge swaths of law with profound substantive implications. I think there's this notion that family law, because it is primarily form-based, that it can be fairly straightforward, that it's mostly assistance based on completing forms. But what rights you have and what outcomes you can pursue can change dramatically based upon the details, particularly when there's a background of domestic violence. And I think some programs like Minnesota have explicitly excluded the work of their paraprofessionals from working on domestic violence cases, which I think is a good step. But also there are many times when one may not even be aware or know to elicit that information, although it could have profound implications. So the substantive complexity, kind of the need for cultural sensitivity and the stigma that attaches to domestic violence all increase the difficulty of perceiving important domestic violence related issues at the outside of client assistance. Paraprofessionals, at least as currently proposed, there's nothing that suggests that they would be prepared to work with domestic violence victims to have kind of a trauma-informed approach and how to best press their specific claims. And kind of one of my biggest concerns is that they may not even realize that they're failing their clients in multiple respects. I was part of a group with other legal services organizations. Earlier last year in September, we submitted in writing comments that kind of reviewed a lot of our concerns from the family law perspective and for low-income clients and for low-income survivors. I think some of the other things that we said in that letter and kind of what has been said today is confirmed by like what we've seen in other states. So in Washington, even with requirements that were already too burdensome that prevented them from scaling up, the LLTs in Washington didn't feel adequately trained to provide the assistance needed. And so I guess when I saw the licensing proposals, a lot of the requirements were significantly reduced. And to us, I think, and especially with domestic violence, there has to be more than just, kind of what has already been outlined. That's less than what Washington had. Washington itself, there were LLTs who didn't feel adequately prepared based on the extensive kind of licensing requirements they had. And so I would be concerned that if they're not working under supervision of an attorney, that the paraprofessionals would be even less prepared here. I think kind of the devil is in the details, and that significantly more needs to be done and more details provided. I thought the status reports were helpful, but there were a lot of kind of conclusory statements and judgment statements that I thought it would be good to know to kind of understand the reasoning behind those statements or those decisions. And I would echo just what others have said before me, that having more people involved, having a diversity of views would also, I think, could inform the process a lot better and ensure that kind of multiple perspectives and all the concerns are being considered. Thank you.
Thank you. Our next speaker is Bridget Graham.
Can you hear me?
Yes.
Can you hear me?
Yes.
Okay, great. Thank you. I will be brief. My name is Bridget Graham. I'm the Administrative Director of the Center for Public Interest Law at the University of San Diego School of Law. And I was also a member of the ADLS Task Force. So I just wanted to very briefly comment to clarify a couple of the comments that I heard this morning from some of the speakers. The first one that I think is important to clarify, and I believe that you as the working group already know this, But I heard someone say that the ADLS task force never intended for paraprofessionals to represent clients in court. And that is just really not true. We actually had some really extensive discussions about what this type of paraprofessional program could look like. And at the end of the day, we decided it made more sense, just in light of timing, to have a separate group. And that's exactly what we have intentionally left up to you all, to really think about this as you're doing, and to think about the scope of practice and what makes sense in light of this crisis that we have here of people not being able to access legal services. So I just, as you know, from our final report, we set out a bunch of principles that we discovered, that we put together and voted on, but we never intended to limit the scope of practice in the way that I think has been presented to you today. So I think that's important to keep in mind. And the other thing that I want to clarify, because I hear this coming up a lot, we definitely heard it a lot at our own task force meetings, is this part about the immigration consultants and comparing them to what is being contemplated with your working group of licensed paraprofessionals. They are not licensed. They are the lowest level of regulation, if you could even call it regulation, and that they have to just register with the Secretary of State. There's no oversight, there's no board. This is very, very different from what I know you all are contemplating, and for sure what we talked about in the ADLS task force. When you're creating a licensing category, you're having educational requirements, minimal competence requirements, discipline, and yes, it's costly, and I think that's part of what you need to be studying. But just because it might be expensive, and just because there are bad actors out there that exist right now, does not mean that we should just throw out the whole idea of having these paraprofessionals. I'm really grateful to the people that you've heard from today, and we heard from a lot of them too in our task force, that are sharing their personal stories about the bad actors they're experiencing. And I know they're coming from a really authentic place of being concerned about vulnerable Californians, the clients that they've seen, and their actual, they know what can happen when there are bad actors, and they don't want that to continue. I believe they're very sincere in their concerns. However, I don't think that that just means you should just stop thinking about these things. I mean, as Jim Salmon pointed out, and I really appreciated his comments, this is a crisis in California. 85% of people do not access legal services. This is something that is beyond fixable by just increasing legal services funding. And just because somebody might be able to make a career out of this, if you have, there's a new category of professionals who might be able to make a living. I think we heard from a few of them today, from having being regulated and delivering competent legal services to people that need them, and they might make a profit out of that. That doesn't mean that they're bad or they're automatically unscrupulous. I think we're all, those of us who are attorneys, we charge fees, we make money. That doesn't mean that we're bad people are going to take advantage of everybody. So I just feel like this distinction is being really blown out of proportion. And I do encourage those who are participating from the legal services community to keep an open mind about how your concerns may be addressed with an adequate regulatory system. I just don't see the connection between having a new licensing category and this parade of horribles of this flood of terrible people that are going to come into California. I'm having a hard time making that logical leap. And I think we all are here for the same purpose, which is to try to figure out how to serve people in a way that will not cause further harm. And so the whole point of our ADLS task force and of what you're here to do is to think of new and creative and innovative ways that can expand those services while still protecting the public. So I just wanted to make some of those clarifications for you today, and keep in perspective what it is that you're here to do. Thank you very much.
Okay, the last speaker is again, Angela Grijalva.
Thank you so much. I promise I'll keep it short. So I just wanted to provide a point of clarity. One of the speakers said that that the paraprofessional wouldn't necessarily overcome some of the barriers that I had spoken to, such as access to printing, filing, access to the internet. Well, as a professional, I would print the documents for my clients and file them. I'm sorry if that wasn't obvious. The other thing I would like to say is, when I was a notary public prior to becoming a paralegal and now a legal document assistant, I'm bilingual and I'm Spanish speaking. So I would get assigned to the Spanish speaking public signings. And I can't tell you how many times I would come across where they were exploited by attorneys, especially the immigration attorneys. My partner, for example, he had paid $5,000 to an attorney to fix his papers, right, as the terms that they use, but nothing was done. When we got together, he told me about that, and then so I called the attorney and I said, you have, by the end of the week, I want a statement or I want a refund. And I got him all his money back. So if you want to say that's practice of law or advocating for your loved ones or family members, it is what it is. But the reality is, no one is going to hold up our Constitution or our laws. We are the ones who do that. We are the pillars in the community. When the DA isn't out here prosecuting, catching every violation of crime, the public doesn't have any other recourse but go to those individuals within their community that they can trust that will help them. And so I am a pillar within my community, and I say that proudly because I do what I do ethically. And I just want to also, I've reached out actively to the DA to try to bring attention to those bad actors within our community here in Sacramento, but we just don't get any communication. I've tried to partner with them. We don't get any kind of response from them. I am a good actor, and I try to publicly and proactively participate and make a change and bring out knowledge of our profession and tell people to be registered. I actively reach out to these rogue paralegals, as the Paralegal Association refers to them as, and say, hey, do you know you need to be bonded and registered? I can't tell you how many people who have gone and become legal, if you will, compliant with the law, because I've reached out to them. It's just they don't know. And so that's it. I'll keep it short. Bye.
Prescott?
Thank you. Can you hear me?
Yes.
Oh, good. Thanks. Well, I'm Prescott Cole, Senior Staff Attorney with CANNER, California Advocates for Nursing Home Reform, which is a statewide nonprofit organization. Our dealings are with senior consumers and their problems in nursing homes. Also, for the last 25 years, I've been dealing with seniors who have been victimized by financial abusers. Well, we're urging caution because the paraprofessional creation actually will create a whole new category of problems for consumers. Two problems. One will be the incompetent paraprofessional, and the other is the predators who will be using paraprofessional licenses. Under the current environment, and again, I've been dealing with financial elder abuse for the last 25 years. And when a senior's been financially abused, then, law enforcement, that's not a priority for law enforcement. So even though when we're looking at the Business Professions Code, the 6126.5, where it could be a misdemeanor for being the illegal paralegal or practicing law illegally. I have never heard of anybody being prosecuted. So if somebody ventures outside their licenses and practices law illegally, law enforcement's not coming in there. And as far as civil litigators, there's very few civil litigators that will take on a financial elder abuse case. And certainly in the arena that we're talking about, these would be, low wealth individuals. So the matter will be, probably less than $20,000 that the consumer will lose. You're never going to find a civil litigator because you can't. And that matter probably is something that would maybe go into small claims court if it's less than $10,000. But certainly it's not worth the civil litigator's time. It's not economically viable to take on a financial abuse case unless the matter really is above $50,000. I mean, that's just the economics of it. And then state licensing, when you have a commercial predator, somebody with a license, that's not a really effective way to go after a predator. Typically what happens is there's been a violation, they pay off. The serial predator who has a license will pay off the victim and go about their business and retain their license. So my experience is that there's bound to be a lot of predators that are going to be coming in using their license. And unfortunately, there's no way to guarantee that a person who holds a limited license will restrain themselves from exceeding the scope of their licenses and venturing into other more complex areas of law. That's kind of the way things are. And it can't be presumed that the paralegals will forego that temptation just to do a little bit more for the clients. And who's going to police this? The state bar enforcement, it just can't be assumed that they can take on this tremendous burden that will be coming their way. I was told some time ago by somebody from the state bar that enforcement doesn't second guess legal advice. That's not what they do. And if this is in fact true, then the consumers are going to be in for a rough time, because undoubtedly there's going to be avalanche. There's going to be just so many complaints coming to the state bar with people that have used a paraprofessional and got poor legal advice. Who's going to police that? The state bar is not set up to, have a tribunal to take a look at, what was practiced here, and if it's substandard, what's somebody going to be doing about it? So if the state bar can't assume that responsibility, we shouldn't go forward. If the state bar does accept that responsibility, what kind of resources will they need? We believe this needs to be something has to be done, but it can't go forward without some really solid guarantees for the consumers. Now, our number one concern really is about the estate planning world, because what we have seen is we've seen actually insurance agents writing living trusts, and they're getting away with that. And there's been problems with the trusts, but we really can't find legal representation, even though there are laws about practicing law without a license. So if an insurance agent either grabs one of these paraprofessional licenses or hires somebody, teams up with somebody, and creates a business where they use the person with a license as a marketing tool, that's going to be very harmful for the consumers. So I don't know, how to really guarantee, safety for the consumer. A couple of suggestions would be, if you do have a limited license, you should have a limited duration for that license to be in effect. And that license should be reviewed and automatically expire. So if there are any complaints that come in, then it'd be easier to deny a reinstatement of or a reissuance of the license. It's very difficult for an entity to take away a license from somebody. There's a whole procedure. But at the beginning, if they have to reapply, that could be cause for non-acceptance if there's been any complaints. Also, they should be subject to the same duty of confidentiality that attorneys have under section 6068 to maintain that confidentiality. And, they should definitely be under the Business Professions Code, the same way paraprofessionals are with 6450, and then the same chances for.
Mr. Cole, about 30 seconds left.
Okay, well, thank you very much for the time. We do, appreciate the effort that's going on. We do understand that the communities are underserved, but everything that we're concerned about is protection for the consumers. So everything that can be possible to help set up a system to guarantee some kind of recourse, that would be optimal. Thank you again for your time and for your efforts.
Thank you. There are no other speakers.
Okay, thank you. I'm very glad we had that extended period of public comment. I do assume there'll be continued interest for public comment at future meetings and subcommittee meetings. So I think that's something we should take up and save some time at the end of this meeting to discuss next steps and make sure we have some time to consider that. So I guess we have to decide. We still have a full agenda to go through the subcommittees. Do people want to take a lunch break now first, or maybe try to get through the licensing section first. Leah and Linda, do you have a recommendation?
I think it's up to the group. I do think we probably need to take a break regardless, a bio break, but I defer to the group. Given some of the comments that we received, the licensing discussion may take more time than perhaps I previously anticipated. That's my only thinking there, but I'm open.
This is Julia. May I speak?
Yes.
I am going to be I think the first speaker of the subcommittee on licensing, and then Stephen is going to speak also. So I'm willing to do it either way. How much time had you envisioned for each subcommittee?
Well, assuming we take something like a half-hour break and save 15, 20 minutes at the end, we probably have 30 to 45 minutes, maybe an hour. Some might take longer than others.
I propose then we take our lunch now so that we can have an afternoon break later on.
I second the motion.
Okay. I think that makes a lot of sense. So why don't we take 30-minute lunch and reconvene?
Yeah.
What's that?
Done much earlier with this portion of the meeting though than I think we anticipated. So we probably have time to just whatever folks think is the best approach. I think we'll have plenty of time.
Great. I do think we'll want to take an afternoon break. So I think leaving time for that makes a lot of sense. So everyone agree with a 30-minute lunch is okay? I think that's what we've done last time.
Hi, just a heads up. I had to schedule a local meeting, 12:15 to 1, because I was anticipating that would be probably a lunch period. So I may be joining back late. I'll try to leave as soon as I can.
Okay, thank you. So why don't we, what time is that back for us? And if we take 30 minutes, I have that.
12:25.
Okay, why don't we plan on being back at 12:25? Thank you.
All right.
Amos.
Yes.
I'm very disappointed you led the meeting and didn't give one shout out to the Dodgers.
Yeah, pretty amazing series.
Should we go ahead and get started?
Yes, let's. Do we need to check who is back and who is missing?
Yes, let's do the roll again.
Okay, just give me a moment to Okay. Bashan,
Present.
Brynolson,
Present.
Falmouth,
Here.
Fleischman, Fleischman,
Here. I'm here.
Hamilton,
Present.
Hartston,
Here.
Kirkmeyer,
Here.
McRae,
Here.
Olvera,
Present.
Shining, Shining,
Unmuted.
Okay.
Here.
Sarouche, Sarouche,
She mentioned she'd be coming back late.
Spyro,
Here.
Torres Ambris,
Present.
Judge Yu.
She'll be also a little bit late.
Okay. Okay.
All right, so I do think we're going to start with the licensing subcommittee to report. And Julia, I think you said you were going to speak first.
Yeah, we didn't really discuss exactly how everything's going to be separated, but I thought I'd start out with talking about how we first decided who we thought would be our candidates for this type of a program. We looked at all of the different states, Arizona, Utah, Washington, and then Ontario. We considered the education, examination, experimental hours, moral character assessment, and discussed a background check. So we talked about a variety of different areas in looking at how you could apply to become a paraprofessional in these jurisdictions. With my background of teaching in an ABA approved paralegal program at American River College in Sacramento, we took a look at what kind of requirements we provide for paralegal students to successfully complete our program and to comply with the Business and Profession Code section 6450 at SEC. And so we decided that, and we looked at the ABA's requirements as well to determine what is it that the ABA requires that is separate and apart from just what the Business and Profession Code sections require. So we concluded that the paralegal, we would like candidates to have already legal education. So we decided that it would probably best be if we had paralegals who had completed the program and were qualified under 6450. And in doing so, that way they would not have to have attended an ABA approved program. So if you are an accredited paralegal program by I want to say it's the Western accreditation of colleges, etc., that would be sufficient. And so we ultimately decided that most of the ways of 6450 subdivision C sets forth who we would be contemplating as a possible candidate for this program. We then took a look at legal document assistance and looked at the any additional educational requirements. There's not that. You just have to have been a paralegal, so that was sufficient. Then we considered graduates of law school who had not passed the bar, and yet they would be coming with legal education that is quite different, frankly, than what we teach in paralegal school. And so as a threshold idea, we were contemplating that law school graduates accredited by California, they do not have to be ABA approved schools either, as well as paralegal graduates accredited by a California institution, which would comply with 6450, were the two main areas that we were contemplating for candidates to be successful in this paraprofessional career. And I think it's really important to consider that there is a division in the type of training each receive. And so when we were structuring the educational credits, we tried to envision how that might be considered to kind of bridge the gap between what the two of them would come with. So in looking at education, we decided that we were going to require additional mandatory education, and we then are going to require additional experimental hours. And I know that Stephen's going to speak to some of that, but I wanted to just also say, in response to one of the speakers that was from the public this morning, that I am able to answer your questions, should you have any, about the Master of Laws program at McGeorge School of Law, because I am also a person who graduated in their transnational business practice program, and I have a Master of Laws from McGeorge. Stephen, do you want to talk about the educational credits, or would you like me to?
I think that you can cover the educational credits, but before we move on the degree certificate, because we were just presented the issue of the MSLs and the LLMs, but it makes sense. Do you have any issue changing our recommendation on degree certificates to include a master's of a law or a LLM?
The only thing I hadn't really given it much thought except for seeing what was written this morning from the dean. And I guess what I can say is this: in my experience, what we did was, I can't really speak to the Masters of Science programs. I'm not at this point in favor of including those. In terms of someone who has been a graduate of the LLM program, like I have, either in transnational business practice or they have accounting, taxation, not accounting, which was the first traditional Master of Laws program at McGeorge. The thing I would say in my experience of the Master of Law graduates is that, yes, they are all gotten some form of a JD in another jurisdiction or foreign country. Some of those jurisdictions are quite different from California. And what I can say is, for example, I did my internship in a very large law firm in Madrid, Spain, and we had some very high profile clients. And for example, just in terms of stare decisis, they are a code-driven society, and case law is instructive, but not, it is not considered binding like it is in California. Discovery, you have to get permission to ask your opposing or your defendant, for example, certain questions if you want to take a sworn deposition. So there are many different legal systems in the world that I would say are a little problematic to say that someone, just because they have a degree in a foreign jurisdiction and now have their LLM, would be the kind of person prepared to enter this program. the one thing that we have to remember is that this is California law, and we are looking to have folks who have been trained specifically in California law because they are going to be working in California jurisdiction. So I have taught in this paralegal program for almost 15 years. And I actually had a student from Ghana who is in the LLM program at McGeorge. And she found it very helpful for a pragmatic standpoint to take paralegal classes because she wanted to stay in the United States and take the bar exam. So in terms of preparation, I am not convinced just in my first consideration of that just because you're an LLM graduate, that you have accomplished enough in terms of California law that you would be coming into the educational process that we are directing in this program with the same competencies that you find with a California JD graduate or paralegal.
I just want to ask, Stephen Fleischman, you've had your hand up. Was that intentional?
It is intentional,
Okay.
and they're done with their presentation. I was going to ask them to address the 2 points in my
Okay, all right, sorry, just want to make sure. Does anybody else have thoughts on this question about the LLMs?
Carolyn, I think it's a good
Okay.
thing to. I think it's a good thing to talk about. I'd like to learn more. You know, I've known LLMs when I went to law school many moons ago who were from foreign countries who were just brilliant attorneys. So, and they're not allowed to practice law. So I think it's a good thing to look into for sure.
I guess my only response to that would be is, you know, how much, I mean, I think what would maybe be helpful is to say it's a possibility, and then let's talk about the educational credits that are going to have to be taken by the candidate who's entered this paraprofessional training. And maybe we could agree that LLM graduates would also be sufficiently qualified to engage in this, because in addition to the education they're coming with, we are going to require additional experimental hours as well as educational credits. So if with that in mind, perhaps with the 18 credits in addition to their previous degrees, we could consider that sufficient to prepare them to be a paraprofessional in California. I'm open to that idea, but I think it's important for us then to first see, before we make that determination, what we have envisioned as the educational credits and experimental hours that anyone going through the curriculum that is contemplated for this paraprofessional to have.
So I see hands up, Ira and Sharon. Are you wanting to speak now or?
Yeah.
Okay.
Yes.
Go ahead, Ira.
Okay. This MLS degree, or MSL, I guess it's called both, that seems to be, Julia, do you know, that seems to have more of a focus on California law than the LLM does. So it seems to be.
Well, the LLM, like I said, you get your master's of law in different things. I don't think that everyone coming to get the master's of sciences or whatever comes in as a JD or as a graduate from a law school in another foreign jurisdiction. I think it's, since McGeorge has become the stellar water rights program, I mean, and in fact, Professor McCaffrey actually has represented foreign countries at The Hague, and it is a very high profile international water rights program, that those kind of things are very specific to McGeorge and they have notoriety around the world. Not all of those programs, like the transnational business practice, deal with obviously international law, but private international law. Nevertheless, some of the graduates did do their
I'm sorry, Julie.
served in public settings. But to get to your point, I guess what I'm saying, Ira, is I was not doing my LLM at the time they had these other programs, but I'm under the impression that they have to do more along the lines of sciences.
I didn't get that impression. And I think you're right that they don't get, most of them don't have JDs already. It seems like something you get that's kind of short of a JD. And it seems to me that that should be, from what little I've learned of it, that should be considered. A second point I want to ask you about is this says, or you mentioned, it doesn't say in the chart, I don't think, JDs from accredited law schools that are accredited by California or in California. And I'm not sure you actually meant that, because the three types of law schools that there are in California, there's accredited by ABA, which we all know, and those are automatically given accreditation status by the state bar. Then there's schools accredited by the state bar. Then there's schools like the one where I work, and about 20 others, I think, that are not, quote, accredited by California, by the state bar, but they are regulated by the state bar. They're called unaccredited, what I should know, registered schools, unaccredited registered schools, but they're graduates. When they graduate, they can take the bar exam just like anybody else and any other graduate, and become a lawyer like any other law school graduates. I think you mean to include these unaccredited registered schools. Am I right?
Well, Stephen, we didn't necessarily agree on that. Stephen, you want to speak to that? You're muted.
You're muted.
Thank you. Unmuted. Our feeling was that for the first round that we wanted to focus on the ABA accredited schools and programs for paralegals, the California accredited programs and law schools, and not having enough information about the other unaccredited law schools, what we would include as being satisfactory for the educational climate. So I think part of it's just to be consistent with the other jurisdictions in terms of what they allowed and permitted, as well as to not setting the threshold at the widest it could be to start off with, but using a narrower threshold.
Did you say?
I would agree, Ira.
Sorry, I want to get clarification on what Stephen said. Did you say ABA schools only?
No.
No.
Oh, you mean Cal? Well, I really think that that's wrong. And let me tell you why. It's wrong to exclude the registered schools. The registered schools turn out JDs who can take the bar exam like every other law school. And boy, if we're going to have people who haven't even gone to law school, like paralegals, how can we exclude people who've got their JDs? I don't understand that.
Well, I think we'd be willing to hear more about it. And, as far as I'm concerned, I'm open to that idea. I thought that in an effort to try and make this the satellite or the initial starting of a paraprofessional career, that we would do something that I think would be the most appealing and appear to be, not, as Stephen said, not the widest net, but a net where people could accept and understand why we anticipate these to be very good candidates for this program.
Let me.
I think we could probably go on this for a while. Maybe we could do another time, but maybe we can
briefly.
Yeah, okay. And just for 1 second, I'll just say we have a lot to get through this afternoon. So I do think the degree and certificate, a lot of interesting discussion on this. It sounds like there'll be more consideration by the subcommittee on this, but I would like to hear about the other parts the licensing did, and we are going to have to set some limits to move on for the other subcommittees as well. So was it
Amos,
Stephen? Go ahead, Leah.
Can you see all the hands raised, Amos?
Let me see.
Because we've got Stephen Fleischman, I think, wanted to wait till the end. I don't know if he still does. Sharon, Claudia, and Carolyn.
Yeah, so I think we should do some comments now since we have raised hands, but I do think we want to at least, and maybe for the other presentations, maybe we could do the presentations first and then get comments, because we could get stuck on each little part. But why don't we go through the comments that we have, if people can try to limit their comments so we can get through it. Leah, do you mind going through it?
I still have my other two comments, but as it relates to the degree certificate issue, I would be in favor of going the other way and limiting it only to ABA accredited schools. My understanding is this is a proxy for taking the bar exam, and there's a huge drop off in bar passage rates between ABA approved schools and California accredited schools and the unaccredited schools. So I'd be in favor of moving in the other direction, but if you're going to look into it further, that's all I need to say at this time.
Okay. Sharon.
Yeah, so my question has to do more with the experiential hours and what that looks like. I don't know if the subcommittee had a chance to fully flesh that out, but I was wondering whether you contemplated whether this is going to be under the supervision of an attorney. I know that we had public comment about that today, or where these paraprofessionals can get their experiential hours.
Can we cover that after we get to that part?
Yeah.
It's my fault, Julia. I tanked the conversation by interrupting you with the question about the MSL and LLM. I think it'd be better if we finish talking about educational credits, which Julie is going to talk about, and then I'll talk about the experiential. And let's do all the questions at one time. I think it disrupts the flow for Julie and I if we try to piecemeal this.
Yeah, that makes sense.
I appreciate that. So what I hope I do this correctly, Stephen. If I've messed anything up, let me know. What we're contemplating is that there's going to be we're going to have a requirement for 3 credit hours of professional responsibility. If you're a law school graduate and can test out of the professional responsibility exam, you're not going to have to go through that again. And then of course, this is going to somewhat depend on the substance of subject matters and scope of representation that this paraprofessional can have. But we figured that since it's going to be more of a truly representation and somewhat advocacy role, for all of the subject matter and scope of each type of paraprofessional, they should have 3 credit hours of evidence, which is practical and not theoretical, 3 credit hours of court procedure, and 3 credit hours of court advocacy. And those titles were taken off of looking at the different types of curriculum in different jurisdictions. Then for each specific subject matter, we wanted, for example, family law. You would have to have 6 credit hours, and then 3 credit hours of that you could test out of. So what we're trying to do is get people through the program as much as possible and give them a curriculum that they could do in a year. So that's that portion. And there are going to be different tests so that no matter who you are, you're not going to be able to just attend classes and then proceed to have this license, but you would have to successfully pass different tests in order to do so. And I think Stephen is going to go ahead and talk about the 480 hours of experimental hours that we have considered as being sufficient.
I would say the experiential hours requirement was the one that we struggled the most with. I think we did not want to be in a situation where we adopted the 1,500 hours that Washington had adopted, because we viewed that as one of the impediments to them developing a successful LLT program because of how much time that's involved. counterbalanced against that was my concern. I just had this image of somebody setting up a mill where they had people do 80 hours a week in a law office with one attorney supervising 10 people to get them their experiential hours, which was not what we envisioned. So we tried to come up with a criteria that was a balance between the low end, Arizona's 120 hours of experiential, versus the 1,500 hours that were in Utah and Washington. And I think when we're, and one of the factors is when we think about Utah, remember when we heard from the Utah judicial officers, what did they had a total of 4 paraprofessionals that they've approved so far statewide. So that's kind of why we lumped it together with Washington. So the idea was 480 hours, especially since we're talking about the paraprofessionals working in a focused area of law. That was kind of representative of 12 weeks or 3 months of working in a specific legal area. And I would say, based on my experience within family law, and I always put my analysis in the context of family law, because I think that's one of the primary areas where we're going to see the paraprofessionals emerge in terms of creating access to justice for individuals. That in 3 months' time, I could do all of the experiential training of a paraprofessional necessary for them to do a competent job to represent people outside of the courtroom and getting them ready for court proceedings. Now, I know there was some concern, could we increase that? Yeah, I don't think we want to go to the 1,500 hours, and we intentionally tried to not create that onerous standard that we saw had been created in Washington. We definitely didn't want to go off of the Ontario model, which is 120 hours, and part of that's because of the 710 hours of education that they require in order to be a paraprofessional in Ontario. So that was the rationale, and understanding that what we were coming up with was a proposal that obviously would engender discussion and comments, but trying to come up with a reasonable proposal that would let us get to an agreed upon number of experiential hours. And again, like I said, we couched it in terms of the number of hours, but also it had to be over a minimum period of time. And in this case, it was 10 weeks.
And I think we also said that it could take place while you're preparing for this program or afterwards, but there was going to be like a calendar limit of how close in time that experience had to occur to the testing portion. And I think we did envision, Stephen, that it would be supervised by a member of the California Bar. And I have no problem saying that we would require them to sign a sworn declaration in support of the students' training, especially on the experimental hours.
Absolutely. I think we were in agreement on that. And I think the only, we don't have it on the screen right now, I think the only thing that might require comments, we had included the criteria that we would not allow someone who had failed the background check or the moral character check with the state bar to become a paraprofessional. And I think it was Steve Fleischman who had suggested that we should expand that to include anybody who had been rejected by another jurisdiction under the moral background check. And I would agree and concur with that. That's a fairly easy fix to our chart that we developed.
I'm in agreement with that. And I think that, for a pilot program, I think, we spent a lot of time talking about how we can make this as acceptable to the general public in terms of having fully prepared students, but also that when they go to a curriculum that we're trying to get these paraprofessionals through a program within a reasonable period of time, which is why we came up with the 18 credits. And I do think that having worked in this ABA approved paralegal program, I can easily consider that this type of a program could be developed in community colleges as well as law schools and other universities. But I think if we want to attract the number of potential paraprofessionals that we would like, we have to make the education portion affordable.
We were in agreement on that.
Okay, so should we open it up for questions and comments? Do we have hands up?
Yeah, I'm going to suggest that we go, I think Stephen Fleischman and then Claudia. I'm going to skip over Ira and Sharon for now because Claudia hasn't yet had an opportunity to ask a question. So go ahead, Stephen.
Stephen, Julia, thank you very much. This was a very, very helpful report. I can tell you guys put a lot of time into it. My comment relates solely to the educational credits part of the chart, the 16 hours, I'm sorry, the 18 hours. My concern is you can have someone who's a stellar paralegal who has spent 10 years doing nothing but, say, personal injury law. They're a certified paralegal. They want to hang out their own shingle and become a paraprofessional. And it seems to me with 18 hours of credit, only 6 related to family law, they could suddenly become a family law paraprofessional. And so, you know, how do you respond? I mean, to me, going from 18 to 60 hours isn't cost prohibitive. I mean, it's roughly a week or week and a half of additional training.
Well, can I speak to that, Steve?
Yeah.
You know, we took, in terms of units, you know, our 3-unit courses are 3 hours per week in a semester. So we were considering semester settings, not quarters. So if we look at American River College and you're taking 3 units, you're in class, I don't know, Leah has the number, we looked at, it was like 56 hours per semester just for 3 units. So that's number one. Number two, the thing I would say is don't forget, they have to pass the tests. So this is another way it's going to be regulated. Not only do you have to, you know, in our school, you have to get a C or better as an average to successfully complete our program. I would anticipate something along those lines as well. And in addition to, you've got to take the paraprofessional licensing exam in a particular subject matter. And if you can't do it, you can't do it.
So, and dovetailing on Julia's comments, when we look at it being approximately, what was it, 56 hours for each 3 units, Julia?
Yes.
That someone would end up having to have 168 hours of education in class, not including out of class time, in class time on family law, and coupled with the, for now, 480 hours of experiential training in that area of law, that would have been combined over 1,000 hours in the specific subject area. And again, I'm using family law as the example. I think that's why we felt, Stephen, that would give them enough information. And again, that is independent and on top of what they've already learned, either in getting their paralegal certificate or in graduating from law school.
Thank you. That was very helpful to me. What I did not pick up on originally was a distinction between credits and hours. I was thinking of it as hours like MCLE credit hours, and that's not what you're doing here. So thank you very much for that clarification.
Okay.
And it is, I think if you, in the posted agenda item table 1, you see in parens, easy to miss, but 1 credit equals 17 hours. So, and the other thing I want to make sure everybody sees is that for some of these, in the other jurisdictions, the credit hours are in addition to the hours required to obtain the requisite degree. And in other jurisdictions, they're inclusive of the credit hours necessary. So in looking at Stephen and Julia's recommendation, it is in addition to. So you've already done the 36, at least. Law school is more like 80. And then another 18 all credit hours.
And you have to pass your subject matter tests, your professional responsibility test, and all of those to actually be able to be a licensed paraprofessional.
So I think it's Sharon and then Claudia.
I think that actually most of my questions have been answered, but the only one that I have is that I know, Julia, you were mentioning that this is a pilot program. Has this subcommittee explicitly decided that?
Oh.
No, but I guess we could define it. I called it a pilot program without definition of the word pilot, simply because it's a new program. I mean, we're looking for the first time to having this paraprofessional program in California, correct?
Right.
That's all I meant by the word pilot.
Okay.
We could call it the rollout, Sharon.
Okay. Yeah, I just, I picked up on that because I actually do think that it is a good idea that we define this as a pilot program and set some limitations on this, and then like build in some ways to check in and some evaluation. And that's the only reason I ask.
I completely agree, Sharon.
Thank you.
Okay, Claudia.
Am I on?
Yes.
Okay. I still see Sharon on the screen.
We can see you.
Okay, thank you. So my question has to do with money. It is my understanding that you are intending to use the community colleges of California to actually provide this education. Is that correct?
That would be one way to get the program out, and I think as the least expensive, yes.
Do we have a range in mind for how much these credit per hour will be?
I can't tell you off the top of my head what it costs at the community college that I work at currently, but it is not a lot of money compared to every other model of education in California.
I thought community college.
Well, I mean, it depends. It depends. If I mean, I went to community college in California, so I know that there's a great difference in between a in-state rate. Like if you're a California resident, right, then there's a different amount of money that you pay per unit versus if you just moved to California. It takes over a year to establish residency here in California, and that would really shift the total cost per unit, even at the community college level. This also applying to international students who do not qualify for the in-state rate at the community college cost per unit level. So I'm just trying to understand what would be the actual cost of this program, since I'm just doing simple math here based on what you have on the chart, 36 units and then 18 more credits. You're looking at like 56 units total. So I'm just trying to get an understanding. So
I think I can answer your question. The community colleges charge $46 per unit. So at 18 credits for under our proposal would be $828. I'm not sure about the out-of-state tuition. I'll see if I can try to look that up. See, non-California residents. The non-resident fee looks to be $290 plus $46 enrollment fee per unit. I don't know if that's it looks to be about $336, but I can't tell if that's the per unit cost. But let's say worst case scenario, that's what it is. It would be $6,048 if you had to acquire all 18 credits through a community college.
And then, sorry, you also mentioned about being able to test out of some of these units. Would there be a cost for those tests? And do you know what the cost would be for that at this time?
No, but we do know that we would defer, we think, to the people who actually are able to design these tests in the least expensive way. And Leah can maybe address that better than I. But in terms of, for example, someone who has passed the professional responsibility exam in law school should not have to repeat that in this setting.
Okay.
Yeah, I think there is a very legitimate discussion to be had about the cost of this program, both for the potential licensed paraprofessional, and I think we can all agree that it is going to be significantly less than going to law school, but still a cost likely. And then the cost of standing up the program, which is another cost. And in the attorney world, those costs are all borne by the licensees, the attorneys, through their annual licensing fee. And ultimately, I mean, that is the model in California for all regulated professions. So there would be, a fee to take the exam, for example. But one of the unintended benefits of COVID is it's taught, I think, the bar, like many other organizations, that you don't have to do things the way you've always done them. So the bar exam, for example, not being delivered in person really drives down that cost. And that could be a similar approach that we employ with this program, that it's an online exam really to bring down the cost. So therefore the cost to the test taker is much lower than it would be if we did it in the traditional in-person model. So that's my input there.
And one thing I would say, Claudia, I can't say that this is going to be uniformly the rule. I think that during those experiential hours, I don't see a model where those are completely volunteer hours. I think people might be getting paid during the time they're gathering their experiential hours. I didn't graduate from law school. I did the law office study program. So I was making an income the entire time I was earning my credits the alternative way. And I can see that. And again, it kind of depends on the employer. If someone wants to be cheap and say, I'm not going to pay you anything for the privilege of giving you your experiential hours, of course, there's going to be people out there that do that. But I think that they're going to be able to subsidize some of this cost through the employment they can get while they're acquiring their experiential hours.
And I'll tell you that is a whole nother situation. Sometimes it is problematic in persuading practitioners to take in people in the middle of a program that are not, for example, at least with paralegals, they can't bill them out as paralegals. They have to bill them out. So they're giving them training, and all of those kinds of issues are dealt with. I used to deal with those issues. Now they're handled mostly at the college level with our work experience program, but those are additional things that would have to be addressed in terms of, agreements with the type of legal employer who would be training during the experimental hours contemplated.
Yeah.
Okay. Are you done, Claudia, for now?
I am. Thank you. I appreciate
All right.
you.
Carolyn.
Okay, I was trying to make notes as everyone was talking to make my things not repetitive, and I'm not sure I've done that. But okay, so with regard to the educational credits, I was asking Linda if we had a fully final list of the things that we all worked on in June, July, and August to narrow down our groups, because I think that would help on the educational credits. If you look at the nice, and this is a ton of work, and thank you guys for putting, everybody who put together this work, it's so helpful. If you look to the educational credits that Arizona and Utah did, they're much more specific as to housing, and the family laws in there, but there's really, I was just looking them up, many more specific and task-oriented educational credits. So maybe that's something you can go back at when you go reconvene and look at what Arizona and Utah did. Washington's just family law. So I think Utah has unlawful detainer. I think we were talking about unlawful detainer. They had some housing. But we had, I think, and correct me if I'm wrong, we had administrative, which would be unemployment. I think we had public housing. We had criminal. There's no criminal in this for expungements, and expungement training is really easy, but it should be on the list.
Well,
and then
Caroline, can I interrupt real quickly? I mean, I think until we have our final list, we were unwilling to be more specific as to what the subject matter classes would entail. So until we get to the point where we have a go on the scope of the subject matters and which specifically they are, then I think we can design that more, tailor it better.
Well, we have the scope, and if we have the list, and maybe Linda can prepare that list. I have some notes, but it would be good to have an official record. I know we don't have the August minutes, so maybe that'll come as a part, an attachment to the August minutes, and then you could use that and not waste time. Let's not wait and say, okay, here we, come back in December and say, well, we didn't know and we got to do it further. So maybe, because I really do think the court procedure, you've got court procedure, evidence, and court advocacy. And I don't know that we need any of that in this. There was one discussion, and I think Steve is going to bring it up. I think there's one area that was erroneously described in a resolution that needs to be clarified with regard to court interaction. And so anyway, my point is this: for your further studies, I think you really need to have that list of what we already decided. And now, with one clarification, I guess family law wasn't finalized. There was a lot of discussion. We kind of cut the rope on that to later. But all those other areas, I would say, there's housing, there's health. I can think of some things, and they're in the Utah ones and the Arizona ones.
But I think we felt they were not specifically enough addressed for us to even frame what the name of a course would be.
Yeah, Linda, can you get us that those final minutes and maybe share that with Stephen and Julia too?
The August minutes have now been posted.
And I think, to be fair, I think this, Stephen, you felt comfortable articulating requirements for family law, even though the group has not finalized its recommendation about what would be authorized in family law. But I do agree with Julia's point. Other than collateral criminal, even housing, all the other areas, we had not done the quote unquote deep dive to really get into what are the authorized tasks going to be, and the sub topic areas within the broader category. So I think Julia and Stephen felt it was premature to start articulating the educational requirements in those areas, and maybe family law was different because of the experience in family law that this subcommittee had.
Julia and Steve, is that right? And you'll go but look back down into it.
Yeah, no, absolutely. So I felt extremely comfortable outlining what I thought would be the practical training and education required for paraprofessionals who were going to offer assistance in family law. That's why you get that kind of specific delineation of the areas. And then what our conversation, Julia and my conversation, realized was what is necessary for family law could be completely different in another area where there's not going to be court procedure. So what we're envisioning is this is what the framework is, and there'll be a more specific conversation in the family law subgroup. And we're expecting each of the subgroups to come back and say, okay, this is what the coursework needs to include if you're going to be doing the landlord tenant stuff. And some of it's, we also want to do is we don't want to be too narrowly focused on the educational requirements, because the more courses that we create that need to be completed, the less likely we're going to find, less likely it is we're going to find educators to teach those programs, or colleges willing to offer those programs. They're not going to want to offer a course for 3 people to attend during a semester. I mean, I think one of the earlier comments about how we have changed what we do in terms of virtual meetings and remote testing and that type of thing will make it easier to get instructors, because we could have a statewide course being offered. It could be, one person offering it, but making it available in all 52 counties. But there's specificity in family law because I felt extremely comfortable doing that. There is no specificity in the other area because we want the working groups that are in those topics to specifically outline what's the educational skill set and knowledge they need to have for us to feel confident about them offering this slate of services.
Yeah, I just did not understand why we would put that emphasis on court procedure and court advocacy if no one's going to appear in court. And they're
okay, so I can answer that directly because they need to be able to educate the self-represented party about what is appropriate procedure in court. So I'm spending probably 10 hours a week in Zoom courtroom, and I am watching multiple self-represented parties who are showing up in their tank tops. Some are lounging in their beds while they're addressing the court. Got attorneys not even wearing jackets in the virtual courtroom. So I think educating the public as to what the court decorum is, how to introduce evidence, all of that's relevant to a paraprofessional being able to instruct and assist that party in preparing for the court hearing. How to compile evidence, how to serve the exhibits in advance, how to prepare a trial brief. What are the legitimate arguments to advance in front of the court when you're discussing child support? That's where that came from.
so that's gonna okay. So that'll pull back into what they ultimately do. But again, I think that needs to be really looked at and maybe turned into something that's a paraprofessional specific thing, because what you just said is not what a lawyer would do, or a legal clinic. I mean, a legal clinic person under the supervision of a lawyer could do that, but to make somebody understand how much that kind of stuff is, at that point, if you're telling somebody all those things, you got to be really careful about, maybe you should see a lawyer about this motion for summary judgment. Are they going to oppose a motion for summary judgment? It just, anyway, we don't, hopefully you guys will take my comments and think about them. The other thing I wanted to say is, I don't understand why we are going below Arizona and Utah. I understand the point with Washington because there were people who said, that's just too much. I can't get through with that. But I guess we're not lower than experience. I'm just wondering, are we saying that the Utah program is a failure already? Are we saying, is Utah considering going under 1,500 hours?
Well, remember, Utah is including those people to now appear and make court appearances, right? That was the new program that they started that we heard about from their court administrator. So,
and it doesn't have educational credit requirements. You have a JD at a paralegal, and then you do 1,500 experiential hours. So it's a different model.
Well, but that 18 credits is nowhere near 1,500 hours. So I was just concerned that we're going to the bottom, and I understand Julia's interest in getting this done in a year. But again, I don't think our goal as California should be, we're just going to go to the bottom with the least restrictive program in the country. I don't think that's the message we want to send to people with regard to consumer protection and really giving people justice. So again, that's a comment, and I don't know if people will agree with me or not. Maybe
we make one observation, Carolyn. Please remember that we're also relying on the testing requirement to really demonstrate they are prepared to do this work. So it's not just a matter of taking the units. I mean, if we find that it makes more sense for them to do more experiential hours than to have the number of units that we're talking about in terms of education, we can consider that. But in terms, and I think Stephen and I both agreed, if you're talking about in housing, the only thing they're doing is unlawful detainers. Well, we're teaching landlord-tenant law in paralegal school right now. I can find out what it's going to take, if anything, for them to need further education, or is it just a matter of practice and then take a test? I don't know.
And Carol, the 18.
I just quickly want to point out, it's not accurate that this would be the bottom, because Arizona, the 24 credit requirement is inclusive of the BA, paraprofessional, legal studies, JD paralegal. So it's not in addition to. So just want to clarify.
And Carolyn, I think Steve Fleischman's question about the 18 credits does show we probably should have done the math in this column, but that 18 credits, that's 918 in-class hours. And if you, that doesn't include out of time. So if you add that 918 to the 480 experiential, we're at just under 1,400 hours.
Oh, that's helpful to know, because yeah, the math looks that way. The last point I had, and I'll be very quick with this, is just what if, in New York, law students need, I think, do 40 hours or 50 hours of pro bono work before they can take the bar, or after they take the bar before they can become licensed. And I just thought that was such a great idea. And so can we maybe require or find a way to include or encourage pro bono hours in the experiential hours?
We can certainly recommend that. I mean, I agree with it, because the point is sometimes it is hard to get busy attorneys with interns in their office with adequate supervision. We may find that the experimental hours are best provided more in nonprofits and things like that, like Voluntary Legal Services of Northern California. So at the end of the day, I don't think, I just want to reiterate, Stephen and I have both agreed, we were thinking of family law primarily when we're looking at what is probably going to be one of the broader scopes of responsibilities that this paraprofessional can have. But clearly, if there are subject matters that are just much more process driven and than what they've learned in paralegal school or law school, then they may be able to take fewer units in that subject matter. This one was truly modeled after the one that Stephen felt most comfortable considering due to his area of practice.
Leah, can you just check us on time? Because I know we still have something like 6 hands up, but we're just going to need to.
So we need to move on to Kim, you, Amos, Ira, and Julianne, and Julie. And then I think we probably should kind of wrap up, identify next steps and additional information requests, and move on to the next area. Does that work, Amos?
That sounds great. Thank you.
All right. So we've got Kim and then you, Amos. Go ahead, Kim.
So first, thank you so much for the time and work that you put into this memo. It's really great to have the information. And I just have questions regarding really the licensure itself. So when you're going to license this individual, are they going to be able to do everything within that scope that they have? Because my question is more towards the testing, because you keep talking about subject matter subcommittees and testing specific to that. And if you issue one license and that individual can do the whole gamut, where are those tests going to be? And then how are you gonna issue individual licenses for each different area that they could practice? Is that kind of the thought? And what would that look like?
I think that was what we thought, and I can't remember, Stephen, was it the Utah Paralegal or Utah Triple LT that came and told us about her experience in family law and how she's able to go to court, talk to the client as the client, but she's not representing her in the proceeding. And I guess the thing is, just because you can be a paraprofessional in family law doesn't mean you can license as a paraprofessional in unlawful detainers. So that's what we kind of considered the model that we heard about and perceived off of the information we received, is that there are going to be separate licenses depending on the subject matter you want to work in.
And separate tests, Kimberly. So if you pass the family law test, you can provide services for paraprofessional services in family law. That does not qualify you to do it in unlawful detainer cases. They're going to have to end up complying with the educational requirements for, if they want to do 2 areas, they want to do, let's say, both family law and unlawful detainer, they're going to have to meet the educational requirements for both. If there's any that overlap, let's say there's evidence that's used in both. They don't have to do the same evidence course over is what we're envisioning, but they will need to take anything that's subject specific or different than the requirements of the paraprofessional subject area that they've already qualified for. And they're going to need the experiential hours for that area. I mean, we're part of the reason too, where I really did struggle with the 480. I praise Julia for talking me off the ledge and wanting to be in the quadruple digits, but because it was going to be very specific to the subject, I felt confident saying, okay, I know if it was me doing the experiential, I could train a paraprofessional in 480 hours to do everything that they would need to do or have competency in. That's a long enough time period, enough of units. And so we would expect them to have to do it for each different topic. Did that answer the question?
It does. I think it adds a whole nother level with this that needs to be considered, especially thinking of cost, because the exams are very expensive to not only do, like Leah was talking about, you know, even if you don't do them in person, expensive, as well as just putting those exams together and having subject matter experts to get those together and develop a psychometrically sound exam. I just think that it adds a whole nother level of complexity to this license that even in reviewing the applications and approving them and making sure they have the education, rather than one global license like is provided to a attorney, to a doctor, etc. I do think that that's something that probably should be further discussed and thought about as well.
I think that's a fair comment. I think the reality is we would end up, if we try to have a global or broader paraprofessional that allowed them to work in all subject areas, we'd end up significantly increasing the experiential hours and probably the educational units. And now we're starting to get towards those Washington thresholds that we view as being one aspect of why that program was unsuccessful.
But if I will add, if this was not, if we envision this incorrectly, we're willing to have more thought on why it should not be individual licenses and should be one. I just assume that would be the most efficient way to get the gaps closed in terms of access to justice, is that one person didn't have to sign up to do all these different things that we're considering, and they could just commit to one kind of practice and in an efficient way be prepared to deliver those legal services.
Thank you.
Okay, Amos.
Thank you. So I want to focus on experiential hours, and I'll try to keep it brief. I think we already had some discussions, public comments and discussions of the working group that these should be attorney supervised, and the attorney who does supervise them should sign off in some sort of way with a recommendation or a certification. I think that's important. There probably should also be a minimum number of years experience for the attorney who signs off. And I think it would be important to have that all very clearly laid out by the subcommittee. So thank you for that. The other thing I want to really focus on is the 480 hours. I think the experiential learning and as part of education and licensing here is really a critical part of what we're putting together. And I was somewhat surprised to see the low number of experiential hours being recommended, which I think you said is something like 12 weeks or 3 months. I think this should be higher and maybe substantially higher. I do certainly appreciate the concerns about looking at what happened in Washington and being concerned to not replicate that. I think an important fact of what happened in Washington is the experiential hours were actually 3,000 hours. They were only recently reduced to 1,500. As some I would suppose, I don't really know, but I suppose it's because of some critiques of that program of requiring too many. But it was about a 1.5 year requirement at 1,500 hours. which may be on the long side, but 3 months I think is certainly on the short side. And I would encourage the subcommittee and the full working group to really think long and hard about maybe increasing that to something more like 6 months to 9 months. So I think 1,500 is probably about 9 months. I do about 40 hours a week, and 480 is about 3 months as my calculation. So I would just really encourage the subcommittee to, I think this is where you get the real world on the job training from a licensed profession, from an attorney doing the work. And I would hope that this is a big part of the licensing program.
I'm not offended by that suggestion. I tended to be on the higher end, and that was where Julie and I tried to work together to come up with a compromise. I need to correct my math. I made a mistake because when I was talking about it was 51 hours for 3 units. So my math was off on the education. It really should be, it's 18 times 17, which is 306 hours. And so I wouldn't be offended personally if we doubled the experiential to 960, which would be kind of a compromise with what you would suggest at Amos on 9, because that would put the experiential and academic units combined at about 1,400 hours.
Okay, and my contribution to that would be, if we're going to increase the experimental, I would really like to consider then potentially requiring less in terms of credits, because I think we have, if this is going to be more of an experimentally prepared paraprofessional, then you're right, and it's consistent with Carolyn's thought, we may not have to provide as many procedural classes or advocacy classes. As part of the curriculum, they may be outlined in the type of experience this paraprofessional is supposed to receive by an attorney. I'll also note that in 6450 of the Business and Professions Code, every paralegal has to be supervised by an attorney who has been a member of the bar for at least 3 years. And I am willing to agree that at least that would be the supervision requirement for this program.
And if I can dovetail on what Julia's comment was too, we were in agreement. The 18 credits was kind of what we were envisioning for family law. There may be a subject area where paraprofessionals are going to be licensed where you can't come up with 18 hours of credits or 18 credits to teach them. It may be so limited in scope. So I'm flexible with both the credits. And again, one of the things that we had specified was, if, for example, in the mock-up for family law, that 3 of those units could be tested out of or satisfied with undergraduate courses. If, let's say, in law school, somebody had took a family law course, and as well as 3 units in the professional responsibility, they would satisfy that by having passed the MPRE. So I'm open to that too, Julia. I think.
Yeah, and I think that we had to kind of envision that the JD comes with probably less experimental training than the paralegal. It's 2 different types of learning in 2 different types of programs. So if they're both what we have to try and reach to become successful paraprofessionals, the curriculum kind of has to bridge that gap.
Do you have any more comments, Amos?
No, that was it. Thank you.
Okay. I think we are at Ira, then Julie, then Fariba.
Just on the experiential hours, what do you think about additional requirements for the who's going to supervise? I just heard that was good. It's got a lawyer with at least 3 years experience. What do you think about 3 years experience in the field that the trainee or paraprofessional is working in? And also a maximum number of trainees per lawyer, or minimum number of hours that the lawyer devotes to supervising the trainee.
I think those are both really good points, Ira.
Yeah, when I was doing the law office study program, I think it was I think it was a 5-to-1 ratio. So I was able to do the hours outside of direct supervision, but my attorney had to directly supervise me for, I believe it was 20% of the time. It's been so long, I don't remember, but that was roughly the formula. I agree with that. And I especially like the suggestion about a maximum number of supervised individuals. I have this horrible image of like a paraprofessional mill where somebody is charging people to give them, not only not paying them, but charging them and doing a bunch of people at one time and not envision, not achieving what we really are expecting from the experiential, but instead running a mill.
Maybe a limit on or a prohibition on charges by the lawyer. I don't know, maybe.
Well, I think if you're a paralegal, they should be able to bill out the person's time as a paralegal. I mean, that's part of the reason folks become paralegals. As a JD, I don't know. I mean, they're law clerks, but at the end of the day, I think we could get into the weeds on that one, but for the most part, I think we're very open to those types of suggestions, Ira.
I meant not the lawyer charging the trainee.
Right, that's what I'm thinking, Joey. Like some guy opens up a shop and offers, like, give me $500 and you can get your experiential hours with me.
Yeah,
that's what I'm.
Yeah,
that's what I was
we'd have to think more on how to prevent that, but I agree.
What are we trained as lawyers to do? Expect the worst of people and prepare for them, right?
So let's keep going. Julie.
Thank you. And thanks to Julia and Stephen for this good work. I like this proposal. I think it's balanced. I think it's fair. And I think it's the product of a lot of thought on both of your parts. I would like to see this group look into additional avenues to qualifying to get into this program, including the Master of Legal Studies, the LLM issue, and the graduates of California registered law schools. I think that would be an important additional thought process. And you just took the words right out of my mouth, Stephen Hamilton. I'm familiar with a lot of licensing programs in California that require supervised professional experience. And to Claudia's point and to your point about the overall cost of this program, not only do most supervisors not pay their applicants, they charge them for the privilege of being supervised. And that's really offensive. And so in the absence of some very clear rules, that has to be prohibited. So you need to think about that too. But I thank you. And I like the thought that went behind every component of this, which is why I would be hesitant to say, oh, let's double the 480 hours. I appreciate the thought behind that comment too, but you balanced that with all your other requirements. So I like it.
Thank you.
Thanks, Greg.
Fariba.
Thank you. I also like this proposal very much, all for experiential hours. I wish we had those requirements for law students before they were admitted. I like the pro bono service ideas, but we don't require that right now from attorneys either. But encouragement, there's nothing wrong with that. I joined in late, so my apologies if you have already talked about this, but how easy is it to locate attorneys who are willing to supervise paralegals?
It can be hard. We tend to, and especially now, I can't even tell you. Especially in Sacramento, where we have McGeorge, Lincoln Law School, Davis, we have several law schools around us, and they're struggling getting jobs, law school graduates. And so many of my paralegals compete for those jobs. The only difference is they have different skills than law school graduates have, more practical skills. But there is hiring going on, but in terms of getting them training, it is going to take an effort. And this is something that I'm very, very interested in doing. I used to do it more with our program before we were ABA approved, but now it has to be offered every semester to keep our ABA approval. But in any event, it can be very challenging, and I think we could come up with innovative ways, you know, to attract lawyers who would like to do this.
And I think that's where the pro bono would come in too, is if we can, as when we move this, when this goes past our recommendations, to specifically target pro bono groups, and he'll work with them to develop the experiential program within their own individual groups. We then create places where these candidates can go to get the experiential hours. So I would definitely say whoever takes the ball from us should be proactive about reaching out to the pro bono groups to try to get placement for the paraprofessionals needing the experiential hours.
And I think what we've heard from many speakers who have come to speak to us and provide public comment, this may be one way that they could really be included in this process in assisting us in training these folks, because they certainly have many services that they offer. That one of the biggest things that we have agreed as a group, I think, that education, even though it may not come from this program directly, what we've learned is that education of these other resources is really important in our communities, and letting people know that there are these other organizations out there. And if they are people who are willing to train these kind of paraprofessionals and help gain those experimental hours in those locations, that may just be a win-win on both sides.
Mm-hmm. And I just want to, I totally agree with it. I just want to make sure we're not setting up a program where these candidates go through, getting the degree and all that, and then boom, they hit this hurdle, and it's either going to take too long to complete their hours, too long to find anyone to do it. And because not just anyone can do this, not just any attorney can do this work, they have to commit to certain supervision and requirements. So I just want to make sure that we think about that pool. I mean, it could also include courts. I mean, I certainly supervise law school interns who want credits. I commit to doing certain supervision. I have to do reporting. I mean, it's more than just, oh, come on in, just come and work for me for free. It's more, there's more responsibility that I have. And I just want to make sure we have thought about, this pool of attorneys and other justice partners who qualify to provide this kind of supervision. But thank you for your hard work.
I think it's great points, Reba. When we were contemplating making pro bono mandatory as part of licensure, there was actually quite a bit of pushback, including from legal services organizations that felt like that puts a huge demand or workload demand on them. So I do think it's a great point and something for you all to consider. Judge Yu.
Hi, everyone. First of all, I'm sorry I came back late. From noon to 1, I was on a panel for the Association of Certified Family Law Specialists regarding racial justice and how that impacts the court. So I missed some of this, and I'm sorry if you talked about it. And my comments are more specific. This looked good to me, and I listened to all the comments. I know probably some of the training will be requiring people to have some elimination of bias training, as we do for attorneys. But one of the speakers talked about having trauma-informed training, and I think that's really important, not just for DV cases, but the whole bench is being trained in that in terms of how we handle our criminal cases. And there's just so much unresolved trauma, especially now with this pandemic and with remote access and all the challenges that are there. I would like to make sure that whatever paraprofessional program that we put in place has some training on that kind of interaction with the clients that they're going to have, because I think that's the wave of the future.
So do you think that is going to be something that is going to be now required as like MCLE credits for lawyers as elimination of biases?
I'm not sure, but it's certainly something that judges are being trained in. And so it would be nice if it could be incorporated. It may not be something that can be required for MCLE, but it is something that's sort of being baked into a lot of training that judges receive. I mean, it's just kind of baked into it. So it's a mindset that people come to their clients with, and as bench officers, we come to our cases and our litigants with.
Very good.
Yeah, and thank you so much, Julia and Steve and your committees for all this hard work. It's really helpful. Thank you.
You're welcome.
And Amos.
Elizabeth.
Hi, thank you. I just wanted to respond to a comment where they said that they would love to see this education program be only limited to those for ABA programs. And so if that were, and so I'm opposing that, because if that were to happen, then that would exclude already like 75% of the LDAs that are practicing and helping the public directly now, because some of them were grandfathered in, some of them went to non-ABA accredited schools. And so I just want to make sure that everyone knew that my position as a legal document assistant, and also on the association of the California Association of Legal Document Assistants, that we, you know, oppose like leaving it only to ABA. And I know you guys are looking to expand it to more people than just ABA, but I just wanted to mention that since I think it's important. The other thing, I agree with Julia, and I'm sorry if I misstate what you said, but you guys would be agreeable to raising the experiential hours, but also at the same time, maybe reducing the amount of educational credits necessary, because in order to allow that, if you're going to spend more time with hands-on experience, you're not going to have that much time to go to school maybe, or it would, going to school and doing the extra hours would delay this program actually going into effect for some. So we're in agreement with that. And we all know that, you know, the training you need to help the self-represented individual, you cannot learn from a textbook. And so that's why I feel like that's a good compromise. And also, you know, these people are not going to be, the paraprofessionals are not going to be limited to just that paralegal certificate, those 18 additional credits or less, and that hands-on training. I imagine there will be a mandatory continuing legal education component. There's going to be additional courses and workshops that Paralegal Association offers, Bar Association offer, so that you can get some of that non-legal specialization education, and you can have some of those, how to work with, like they mentioned, how to work with clients of low-income backgrounds, being culturally sensitive, so that kind of thing. So I think that's all I wanted to mention for now, but thank you for all the hard work so far.
Julie, do you want to address the issue about the grandfathered paralegals?
Well, I mean, no, Stephen, why don't you? Because I think I am more willing to do it than you are.
Okay. I think the way that we wrote it was anybody who's currently a paralegal, Elizabeth, however they got there, which would include the grandfathered individuals, we included them. So they're not barred by these rules. The ABA accreditation had to do with someone who's not yet a paralegal, hasn't met the criteria, and then starts this program. So if they're already a certified paralegal, I think we said that met the criteria for the program.
Yeah, I think what we decided that even the ones that were grandfathered in under 6450, which I think sunsetted in, I want to say 18 years ago or something, right. You could only have done it if you had that we didn't want folks that just had a high school education, but if you were grandfathered in under 6450, you had to have been grandfathered in several years ago. So I figure if you have been a paralegal that long, it doesn't matter if you are a high school graduate, you were under the laws of the state of California, approved to work as a paralegal, so that we would recognize. Yes.
Okay, perfect. And just to clarify, 6400, the legal document assistant, in business and professions code section also has a grandfather clause that's different than the 6450. And again, just says if you had a high school diploma or a bachelor's degree, then if you were already doing self-help work prior to 1999, then you were grandfathered in. So there might be two different clauses for being grandfathered in, but I just wanted to mention that.
But it was it before 1999, so 11 years ago or 21 years ago.
Yeah, that's how
You
some
were
of the LDAs
grandfathered in
are
and
working.
have been doing this work for 21 years. I don't think that Stephen would have a problem with it. Would you, Stephen?
Shaking the head, no.
Thank you. Thank you.
Okay, it looks
All right.
like we still have a number of hands up, although it does look like some people have spoken before. I think we should try to wrap up licensing by 2 so we can move on to some of the other. Leah, can you walk us through how to?
Yeah, so let's go to Greg and Donna. Greg took his hand down. Donna, and then I'm not sure, Julie, Judge, you and Sharon, if you have new comments, but let's hear from Donna.
Thank you. I wasn't going to say anything because I had to step out for about 35 minutes and I didn't know where you'd ended on this, but since Elizabeth just mentioned it, I know it's apparently still a live issue. So I did want to talk about the discussion that you were having about limiting limiting the JD to ABA approved schools. And frankly, even the initial proposal to have ABA approved in California accredited schools, but not registered schools. California really has a unique opportunity here that that other states don't. We've got the registered schools and we've got the California accredited schools that are giving a law school education to individuals. And to be clear, some of the folks who are attending the California accredited schools and the registered schools, these are opportunity schools. They provide options for people who maybe can't go to take a full-time law school program. They're single parents. They are working in areas where they are living in areas where there aren't law schools. And up until a couple of months ago, we didn't accredit online law schools at all, and we just started accrediting. So if you needed to do it online, that was going to be a registered law school. I think we have this real opportunity to have, as paraprofessionals, people who have a law school education at schools other than ABA law schools. And I would really caution us to limit the proposal. If we're talking about people who have a JD, I really would argue strongly for having a JD for ABA approved, California accredited, or California registered schools.
Stephen, I'm willing to consider that.
I'm taking a look at, we're talking about, in terms of fixed facility, there's 6 of them, including Iris College. Then I see 4 that are distance learning, and I don't think that they overlap. They don't. So we've got 4 distance learning schools. I would be, I don't know. I got to think about this one. I think the other thing too, do we have bar pass rates broken down between, I mean, I don't like using those as a metric because of the arguments of bias, but do we have bar pass rates broken down by accredited, unaccredited ABA?
Yes.
I'd like to see those. I think that would help inform me in my thought process.
And remember that today you're just getting feedback and inputs. You don't need to make a decision. Just put it on the list of additional things to consider. So Sharon.
Yes, so I'm going to be quick. I agree with a lot of what's been suggested today, including Judge Yu's suggestion of including trauma-informed care as part of a curriculum, and also expanding experiential hours. I know that someone brought up, a few of you have discussed pro bono, and I would love to explore the idea of formalizing fellowships with legal aid organizations, because we know that the quality assurance is there. Of course, none of this ever comes for free, and fellows would still need to apply and be vetted, and supervision would need to be provided, which may take some funding, but perhaps we can get creative in how we think about that.
Okay. I think that's your last hand, Amos.
Okay, great. So very good discussion. It does sound like there's more work for the committee to do, but thank you so much for that. And I think that will take us, I don't know if we need a break. Why don't we try to do the regulation and then take our break, if that works for people, so we can jump into the next topic. So regulation, I think I'm going to be speaking first. It was myself and Fariba, and please, Fariba, jump in as you see fit. And of course, we had a lot to cover. So, oh, thank you for the slide. So one of the things we did is just try to get a sense of what our regulation committee should include. We did look back at the ADLS report, and we thought about certainly the first two here, continuing education and financial responsibility, which we'll talk a lot about today, are on there, but it wasn't clear what else. So we did want to sort of make clear what we were considering and what we weren't. And there are a lot of things that we are not considering that are important topics that need to be considered. That's both in the report and on the screen. So I'm going to focus on what is included and what we're talking about. But one of the ones that could have been included, for example, is the name of the program, because I think that has to do with how people know it and if people are misled or what it includes. So it's something the working group should consider. So there's a lot of stuff we're not considering. There's also a lot of stuff we are. Out of these 8 things that are on the screen, I think we're going to talk really in detail today about 4. Financial responsibility, continuing education, fee limitations, and then at the very end, ethical standards. And on the other column, the drafting the rules of professional conduct. So I think we had some initial discussions about everything on here. We're going to need to do more work on them, but we're going to focus on those 4 things. So first, I'd like to talk about continuing education. I think we did come up with some agreements and some proposals that are specific that we can talk about, similar to what the licensing group did. We looked at a lot of different things, including what continuing education was required for attorneys and paralegals in California, what requirements are from these other paraprofessional programs in other states. Where we ended up was really focusing on what the specialists in California are required to do for continuing legal education. So just to give you ballparks, California attorneys do 25 hours every 3 years, which is about 8 1/3 hour every year. Paralegals do 8 hours every 2 years, which is about 4 hours every year. Specialists do 36 hours every 3 years, so that's about 12 hours per year. And everything else is on that continuing. So Washington is 30 hours every 3 years, so about 10 hours a year. Ontario was the highest with 12 hours every year. So it's a continuum, but we thought either the attorney's CLE requirement in California or the specialist requirement in California was the right benchmark to use. So we did end up proposing 36 hours every 3 years, which would be the equivalent of 12 hours per year on a 3-year cycle, just like attorneys, for the bar to be able to manage it along with the current MCLE credit. Now, what we also did was we took the existing requirements for attorneys in terms of what those hours are focused on. That includes 4 hours of legal ethics, 1 hour of competence, and 1 hour of elimination of bias, and had the balance of the hours be focused on the topic, the specific area where the paraprofessional is practicing. So that's for continuing education. We welcome ideas and suggestions, but this is something that we did come up with an agreement on. I think it makes a lot of sense, and we're open to further discussion on that. We spent a lot of time on the financial responsibility. This is, so if there is an issue that comes up, hopefully there won't be, and hopefully there won't be many, but to the extent there is, that there is some way to recover.
If I may chime in, I'm so sorry before you move off the continuing education. Thank you. That was totally complete. I just wanted to add in that to me, the public comments talked a lot about consumer protection. And to me, consumer protection is not about completely eliminating this possible opportunity to earn an income and make a living. To me, it's all about the licensing requirements we just talked about. To me, it's all about the educational requirements, continuing education requirement. To me, it's all about imposing rules of professional conduct and also to police it and enforcement. So to the extent that we're presenting our report, I think we agreed on certain things. Like this one, we didn't agree on other things, but I want to make clear that that was my line of thinking.
Great. And anything else on the continuing education that I didn't cover?
No, I think that you made clear that we kind of felt like because the licensing requirement was that we were requiring that they pick an area of specialty, that this was in a harmony with that, to sort of ask them to also take specialized courses for continuing education unit.
Yeah, and I would be very open to trauma-informed training as part of this as well, or other maybe increasing, even though we use as the baseline the requirements of training for attorneys in terms of legal ethics, competence, and elimination of bias. I also think we might want to increase some of those requirements for the CLE. So I'd be very open to thoughts on that. I think we would both be very open to thoughts. We just sort of started with what the attorneys do and focus everything else on the practice area.
Yeah, I think trauma-informed training, trauma-responsive and trauma-resilience training is really important for not only paraprofessionals, but attorneys as well, especially I want to say in the area of family law, where there probably are going to be helping both survivors of IPV and also perpetrators. So it's very important to understand those dynamics before getting into the case.
Great, moving into the financial responsibility. So this is another one. I think it was included in the ADL's recommendations that we at least consider malpractice insurance, a bond, or some other way to ensure that there is some financial responsibility if there's an issue. So I think we spent a lot of time talking about different options. I think where we ended up, as summarized in our report, is we didn't come to an agreement, except at minimum, I think we should encourage malpractice insurance, and the bar could take steps to make it potentially available. One issue is this is a new licensed proposal, so there may not be insurance available immediately, or we don't know what the cost is, but the bar already has taken initial steps to see if it could be made available. Malpractice insurance is required in some other state programs and available. So, so the discussion really focused on malpractice insurance is not required for an attorneys. So why should it be required for these licensed professionals? And I think we need to have direction from the full working group, because we just didn't reach agreement. I think Fariba, as she mentioned, and I'll let her speak for herself, I think clearly expressed that if it's not required for an attorney, it shouldn't be required for licensed paraprofessionals. I came from a different point of view, which is we're creating a new licensed professional. A lot of licensed professionals have financial responsibility requirements, if not insurance, bonds, and others. And I think we should learn from the examples of our state experience that we've heard some public comments, but in terms of consumer protection, we really have a balance to provide access to legal services, but also for consumer protection. And I think this type of financial responsibility, something, if not required malpractice, then some sort of bond or fund, I think is really critical to balance that out. And so we didn't come to agreement on malpractice insurance, except to say, we should try to make it available and try to encourage people to have it. For surety bond, we also didn't come, I think it was really the same discussion. It's not required for attorneys. So maybe it shouldn't be required for paraprofessionals. I think it is required for many licensed professionals in the state of California, including immigration consultants, legal document provider assistants, and contractors, all sorts of licenses have it. We did not spend a lot of time figuring out how much protection it really provides. So I think we're going to need to hear from more people about having a bond requirement really does provide some protection. But I think we also are going to need the working groups, considered analysis and comments and suggestions, because we didn't agree. One thing we did spend some time talking about as well is a client security fund or a restitution fund. So attorneys have a client security fund. My understanding, and I might botch this, is that it is limited not to malpractice claims. So it's not for errors and omissions that would be covered by something like malpractice, but it's really for fraud or intentional conduct like theft. And for most of the time, it requires advanced finding of discipline or criminal conviction or some sort of finding before any recovery. So it's usually a long process after discipline or after a criminal case, and then it is limited with a cap and only for intentional conduct. So I think, again, here we had agreement. There should at least be a client security fund, the same as attorneys have it for paraprofessionals. Where I thought we might want to expand on what that looks like is, especially if there's no malpractice insurance required, that there be some sort of fund like we have in other areas, where there might be some recovery that for errors and omissions, for negligence, malpractice, if there's no malpractice insurance. But again, we talked about that would be hard to administer, expensive. We'd have to figure out how to fund it. So there's a lot of big red flags before we can move forward on that. And again, I think we need feedback from the full working group, because we didn't reach agreement or conclusion, but we did have some discussions about what it could look like, what other funds exist, what's out there. But I think we sort of are a little bit out of the impasse, because on one hand, there's the consideration it's not required for attorneys, so why should it be for paraprofessionals? And the other hand of trying to have some increased level of regulation and consumer protection for licensed individuals. Fariba, I'll stop there for your comment before I go on to other topics.
Thank you. I think that graduating law school and passing the bar doesn't come with a chip implant of being ethical. I think that we certainly have seen a lot of unethical attorneys who take cases they have no business of taking. I see that firsthand here at the Self-Help Center. I've been doing this job for 22 years. I've seen massive ethical violations by attorneys, and I've seen them by a lot of people who call themselves notarios or legal document assistants. Of course, legal document assistants at least have some sort of licensing. And then paralegals, even though paralegal by legal definition is a professional that works for an attorney, or is more for an attorney, yes, with an attorney. So I just think that if we're gonna, this is about licensing a new group of professionals who are doing attorney type work to a certain extent, then they need to be regulated by the same regulation, rules of professional conduct, State Bar Act, and we shouldn't require more than we require from attorneys. To me, that's treating them as a suspect class, like right out the get-go, you must be dishonest and we have to regulate you more, That's, to me, that's what it comes across. And I think there were some comments today that, for example, the members of the public that may hire these professionals are not necessarily going to be low income. They're necessarily not going to be stupid and uninformed. They just want to, we get people here of multi-million-dollar estates who come to Self-Help Center and they have no business of being here, So, but they do, that's what they want to do. So as long as I think we tie it in with, for example, disclosures, I think, to have mandatory disclosures by these new professionals, licensed professionals, that say who they are and what they're exactly doing, what they're licensed to do, to help potential client to become informed and be able to make informed decisions. I think that's consumer protection. It's not to treat this new group of professionals as a suspect class versus new attorneys. I think they're both capable of making bad decisions, bad judgment calls. We just provide the training, and as we do with attorneys, we hope that they do the best they can, not like my former classmate who 2 years after beginning of law school stole a signature stamp and was stamping his own temporary orders. And I know because I represented the other side in one of his cases. Anyway, so that was where I'm coming from. I'm just saying, encourage, either required from attorneys. I really think that attorneys should have malpractice insurance. I think there should be an easier way for victims of attorney misconduct to be able to collect their claims faster and not have to wait for completion of another long process to get reimbursed for their loss. But if you're not going to do that, then we should not do it for this new group of professionals. And finally, if my understanding is correct, whenever we get to a point where this program launches, then and please correct me if I'm wrong, there's not the only way people can perform this work is by getting this license. Otherwise, it'd be unauthorized practice of paraprofessional work. Am I correct, Leah?
Yes.
Is that the plan?
Yes.
Yes. Okay. So so remember, right now, there are paralegals and LDAs and notarios that do this work without training, without taking CEUs, without, having any sort of restrictions. They just hang a shingle and say, yeah, I can print judicial counsel forms and check a few boxes, without any responsibility for doing really bad work. So if we can have this program where they're licensed or monitored and they have to get this minimum education and experiential training, and then of course doing CEUs, then I think we're much better off than we are right now and meeting the needs for access to justice.
Okay, great, thanks. And I'll try to keep this next part brief. I see there's a slide up for restitution fund design. We talked about this and again, so I think we were in agreement that there should at least be a fund similar to attorneys, the client security fund, that would include deliberate acts like theft or an equivalent, or funds wrongfully retained. But the idea would be potentially to extend it to unintentional errors like malpractice. Eligibility requirements, we also talked about that. In the existing client security fund for attorneys, it requires the first discipline. So we talked about maybe not requiring that, or a malpractice judgment or a final determination of discipline, but maybe a complaint being filed, and then having, maybe a cap on recovery. But again, probably some real big issues with a fund that we'd have to really consider about how it would be funded and how it would be managed, if that is something we're going to seriously consider. Two other things I want to quickly talk about that we talked about, fee caps or fee limitations. So again, we didn't come to agreement on that, and I think it would be important for the full working group to weigh in and give us some guidance. I believe Fariba thought that there should not be any fee caps because attorneys don't have fee caps. And again, as she explained, let's not come in with a pre-existing feeling about who's going to be the clients and that there's going to be bad people taking advantage. My sense is the main point of this program is to find a lower cost alternative for people than attorneys. And again, as a consumer protection, my feeling is that there should be bright lines on fee limitations and fee caps to make sure that we are really focused on providing access as a lower cost alternative. And finally, I don't know if you can go back to the slide that has what we considered and what we didn't consider. What we really identified was that as part of regulation, we need to have a rules of professional conduct similar to attorneys. So, there are, as one of the public commenters mentioned this morning, we have experience with professional rules of conduct for attorneys, and a lot of the same rules can and should apply to paraprofessionals. So we really have to go through all those rules. And I think what we decided was our committee would, for ethical standards, maybe make recommendations on what the rule changes should be for paraprofessionals, but that probably we're going to need to draft professional conduct rules and propose changes to statutes to allow for confidentiality and privilege and those sorts of things that are really going to, take a lot of work to work through. The four that we are not ready for proposals are the mandatory disclosures, the proactive risk-based regulation, informed consent requirements, and advertising limitations, but we do recognize those are on our plate and we're going to work further. With that, I'd like to open it up for comment, especially on the continuing education proposal, financial responsibility fee caps.
And I just have one more comment on the fee caps. Just wanted to add that, in my opinion, we're living in a free enterprise economy. We're living in Google and Yelp age, and market would regulate itself. And people are gonna, again, these litigants are not all simple and stupid and they don't know what they're doing. They're actually gonna shop around, and they do that now. With services that LDAs and private paralegals provide already. So I think they're just gonna, market is just gonna regulate itself for people who wanna have a viable business out there. And they're not gonna charge exorbitant fees that's much different that the market will allow.
Great.
We have a lot of hands. Leah, do you mind walking us through?
No, let's go. Steve Fleischman.
All right, so let me start with insurance. I'm opposed to mandatory insurance for a lot of reasons. I would encourage everyone to read the State Bar's most recent report on requiring mandatory insurance. It's linked in the memo that I circulated. Essentially, the committee, and one of my partners was on the committee, concluded that there wasn't enough information, there wasn't enough data out there on the subject. On the other hand, since we have an existing license bond requirement for LDAs, and since paraprofessionals will be somewhat akin to LDAs, I'd like to hear from Elizabeth, but if the $25,000 bond requirement has not been an impediment to LDAs getting their license and practicing, then we may have a very good coincidence if we limit all of the appearances, and that's a big if there are going to be court appearances, and that's an if, but if we're going to allow them, and if it's limited to limited jurisdiction court, coincidentally, that's $25,000, we may be able to kill two birds with one stone. Something else on the financial side, I didn't see anything in here about a bar on referral fees to or from attorneys. I think that should be included in the regulation, that there should be a prohibition on that. We have talked about that before in many of the subcommittees, particularly employment. With regard to fee caps, I would be in favor of fee caps. And there are situations where attorneys have their fee caps by statute. One is medical malpractice, another is workers' compensation. So while Fariba, usually I'm a free market type of person, and I, on one hand, agree with you, I'm very concerned about consumer protection. And I think this would be appropriate for the reasons Amos articulated to have fee caps in place. There are also additional fee caps on attorneys by case law and by the rules of professional conduct. So I don't think the idea that attorneys can charge whatever they want is necessarily true, and I'd be in favor of that. If we're not going to deal with the costs of startup, my other comment would be moot. In terms of the client security fund, I would very much be in favor of that, in addition to the bond, for cases the bond may not entirely cover. But I think it needs to be segregated from the attorney fund. And because otherwise, essentially, you're going to be taxing attorneys to run the paraprofessional program or the other way around. So I'm in favor of that, but I would want it segregated. Do you two want to respond to my comments and I can respond to you, or do you just want to move on?
I just, I thought I heard a comment earlier this morning in the public comment session that about paralegals having the judgment call to refer complicated cases to attorneys. And I made a note to myself about referral fees. And I'm just wondering, do we want to provide that incentive or allow for that? Just kind of brainstorming here.
We addressed that during the employment subcommittee, and there was a great deal of concern that we don't want to turn these paraprofessionals into runners and cappers. And we heard, from example, from employment lawyers, plaintiffs lawyers, that, you know, this is a real problem, that even somebody who's the incoming president of the Consumer Attorneys of California, you know, she's had people approach her wanting kickbacks on cases. It's a real concern for me. I think it's a real concern for the plaintiffs bar, frankly. I'd like to hear Carolyn's input on that, but I see a lot of problems if we don't have that prohibition. That's a long-standing prohibition in California. The runner and capper statute goes back, I think, to the 1920s or 30s. It exists for a reason. It's a problem. We should continue to enforce it.
I do have some thoughts on that. I don't know if I'm next in line.
You are.
Okay. All right. So that's one of the last things I was going to talk about, but I can put it first. It is a big problem, and it is one of the things I attended pretty much every ATILS 1 meeting after July, after they put together their preliminary final report in July of last year. I attended pretty much all of them and read all their materials. And Bridget Graham, who gave us, I think she was the last person who gave us testimony. I don't see her on there. Otherwise, I'd say, hi, Bridget. Bridget came and met with us in Sacramento and gave us kind of her insights on that. And there are a couple issues in this regulatory thing that really bear consideration with what the ATILS 2, I think it's called the Committee for Closing the Justice Gap group. I don't think it's started yet, but it's going to start up and work in parallel with us. Bridget pointed out how we split it into two entities, but with regard to that referral fee issue, that group is considering very significant changes to the attorney advertising and all kinds of these things. 7.1 of the new rules that model the ABA rules. I'm sorry, 7.3, 7.1, that 7 series that might, you know, this could inadvertently or at the same time parallel us, where we're talking about bending all those rules and having the sandbox people come in and say, we need these paraprofessional rules, we need these attorney rules bent in order to make this happen with Amazon law, Walmart law, like Professor Sandifer talked about. So that's a big thing, and I think that's something, it's very deep. It haunted every hearing of ATILS after the 3,000 public comments that they got. And so I don't know if they're going to redefine it, but it's something that really is going to be a challenge legally to really think through, because it is a serious issue. But then also there's a conflict problem. So let's say we do allow referrals and the rules get bent and 7.3 is changed. Then how does the paraprofessional know when they're going to refer something versus I'm going to get my extra money and finish this, but this person should really be referred. Again, we've narrowed those issues of the areas of law. I think we've narrowed them almost significantly such that, you know, with a few exceptions, maybe in healthcare, HMO law, you know, that's not going to be an issue. But so that's a huge thing. I think that runner capper thing is going to hit us both ways, and we need to be looking at what the sandbox is doing coming down the road. So then my actually where I was going to start on is on this side, the financial responsibility side. Okay, in ATILs, one of the things they talked about here, and I think Linda worked like for 2 years, and bless her, on that medical malpractice issue. And I think she really put a ton of, I've heard she really put a ton of work into that. And I have mixed feelings about it because, you know, I've seen the good and the bad. I know it's expensive. I know, you know, malpractice insurance can cost a solo attorney $4,000 or $5,000 a year. But I've seen people, again, you just know things anecdotally. You see legal malpractice cases where clients are left out in the cold. So it's a big issue. You know, we have to tell people when we have insurance and we don't, in writing. You know, for those of you who are non-lawyers on the group, we must tell you in our retainer, but people can put it in there in tiny language, and the state bar looks at it and goes, that was in tiny language. You should have told them a little bit harder. You didn't have malpractice insurance. So it's still a huge problem. In order to answer that, the ATILs people suggested, the technology people who were not lawyers suggested that companies have E&O insurance. So if you're a company, your paraprofessional goes out and they incorporate themselves, then they will carry general corporate insurance. So there may be a way to require them to do something that is not necessarily legal malpractice, but in a general sense, what people on the technology side said, no, corporations get insurance. It's, you know, it's a thing, don't, you know, calm down, corporations get insurance, it will cover this. Then also, but I think the commenters brought up a point, which was that there could be these click-through licenses. And so if a paraprofessional online, because we're thinking of the, you know, Professor Sandifer talked about the little person next to the dentist office with a storefront, but there's going to be the Walmart.com. And on the Walmart.com, they'll have a click-through, you know, click, 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 click. And in that click-through, it's going to say, I waive all conflicts of interest. And I waive all these things. So I think we, again, in the regulatory subcommittee, we need to say no arbitration, no waivers of, you know, class action. You know, there's things that are done every day to people that you cannot undo. You know, sending an individual to arbitration, which is going to have a $5,000, $8,000 fee. So in that financial responsibility section, if we're not talking about malpractice, then we need to maybe think about corporate E&O, and we need to think about preventing that click-through language with a teeny tiny waiver of arbitration, waiver of court appearances in favor of arbitration, and that kind of thing. So, okay, on the, and I'll try and, this is, you know, again, these are such crucial things, and I'm glad that we're not voting on them today. And I would ask that if, you know, when the committees come back, subcommittees come back, and I'm not sure, I heard the request for transparency, but I see how much work you guys have done. I'm not sure, you know, the rest of this, you know, this is a tremendous amount of work these 3 subcommittees have done. But I would like to see the reports sooner. And if we have any resolutions, I am hoping we get those at least a month before we are required to vote on actual resolutions on how to implement these things. And hopefully we have time. On the client security fund issue, I guess I don't really have a position on that. I never really thought of it before until I saw these things a couple of days ago. The trouble with separating it out, with all due respect, Steve, is that if we get 1,000 paraprofessionals, which would be fantastic in terms of comparing with Washington and Utah, and, then that's not very much money. These people aren't going to necessarily get retainers. So, you know, plaintiffs lawyers, actually, I've always wondered if the state bar keeps statistics, plaintiff lawyers who get in these big, you know, these big multi-million-dollar settlements, and that money is in the trust fund for, you know, a month before it's distributed out, or however long it's legally, you know, acceptably held there until it's dispersed. I wonder if that funds the IOLTA funds. So if we do a client security fund with only 1,000 people, as opposed to 200,000 lawyers with, you know, 30,000 plaintiffs lawyers in the state, I don't know if that's economically going to get anywhere. It's a good idea, but I just, you know, the economics on that, I don't know. And then lastly, on fee caps, I think it's a great idea, but, you know, I don't, but it's, again, the ATILs people are going to, the sandbox is going to have an economist or two. There's actually going to be a member of that committee that's from KPMG. I am certain they're going to talk about the economics of these programs and the you know, the Walmart.com. So we may get some of that data on what a fee cap would look like. But I do know, again, 2 instances where I know of a consumer debt company that, you know, the things on telephone poles and, you know, we'll clear your debt. They are charging a lady $200 per month to negotiate her credit card loans, like $30,000 for the credit card loans, they charged her over 2 or 3 years, $200 a month. I mean, that was far more than she got reduced. And she just could have called up the credit card companies or just started paying them back. So that was a problem with that subscription-based model. And again, same thing in divorce. You know, there's some of these online divorce companies
Carolyn,
all across the country.
I'm sorry, but there's a lot of people with their hands up, so I just want to.
Okay. These are huge issues, and I'm not part of the subcommittee, and these are things that I would be raising because the educational thing is, you know, Julia's, you know, got all that background in it, and this is amazing and enormous. And the same thing with the discipline. I really think we have to go into this in depth. You know, I don't know if we have time. We did 24 meetings this summer on our 4-person subcommittees. And so I don't know, sorry to take up so much time, but I do have a lot of factual input on this. There's more that I could talk about, but we really have to take maybe 2 meetings to vet this out, maybe a whole meeting to vet this out.
Okay, Sharon and then Julia.
Thank you to Amos and Fariba for all of your work on this. To me, it is clear that in order to have sufficient consumer protections, we're going to have to include financial responsibility. It's just a matter of how. Otherwise, how do victims of incompetence get redressed without having to sue in civil courts? So if we're not talking about malpractice insurance, why not a bond? And I guess I still want to hear more about that. I like the idea of a restitution fund that would compensate clients for both intentional wrongdoing and negligence and malpractice. And I'd be in favor of that. I'd also be in favor of segregating this out from the attorney's fund, as Stephen Fleischman suggested. I'm just really, really concerned about the viability of funding and how this would be administrated. So like, if that is like the only thing that we're talking about, I'm not sure that that is going to give us sufficient consumer protections. So I would like this group to really consider the bond, maybe in addition to that. And I am also in favor of fee caps.
Okay, Julia, and then Judge Yu.
Okay, so I wanted to clarify something because I'm not sure if I misheard it or I can't remember the conversation, but I think Fariba, I'm not sure who said it, that they heard this morning that there are paralegals who can share a fee or refer things out. That is not legal.
No, that's not what I said.
Okay, what you said?
Once this program is created, if it's created, then what if a case becomes too complicated, and we want to have paraprofessionals who would recognize when it's too complicated and refer it to attorneys. And my question was, do we want to incentivize that by allowing a referral fee? It was just a question off the top of my head.
Yeah. Okay, because I was just, number one, I wanted to make sure that no paralegals cannot share a fee legally with an attorney. And so that is not legal in California. Also in the paralegal business and professions code sections, no running and capping there. So I think they should be the same for this paraprofessional. And I think the distinction I would say is, I kind of agree with the statement that this is more similar to the LDA in the sense that these are new professionals who are opening up business and have not gone through the financial investment necessarily of a law school or passing of the bar to be able to do those things. There are many barriers to becoming a lawyer. And yes, once you become licensed, you can do whatever you want unless you mess it up and then you get in big trouble. But I think the reality is there has to be some sort of a bond, if not insurance. There has to be something present. And I too would like to hear about what Elizabeth has to say in terms of LDA And I like the idea that we're limiting it to 25,000. I think that when we have been talking about this, this has not been an idea of unlimited scope of practice. I think it is more targeted. And I think if we view it that way, we can come up with some more simple answers in terms of if we're dealing with a certain type of person who has a certain need, we're not going to have common problems of having these multi-million-dollar cases or hundreds of thousands of dollars at issue. I just don't, I believe that those people would find an attorney that would be willing to take this kind of a case. But I do have a problem with referral fees. I'm not sure how to handle it, but I think since paralegals are always working under the supervision of an attorney, it wouldn't have even come up that they would, why would they get a referral fee? They can't work independently. So my feeling here is there's going to be a referral to an attorney at some point when we say, okay, now you've gone beyond the scope of practice and that anything more complicated will have to go to an attorney. I'm not sure what the answer is because I haven't considered this and worked on this topic, but I do think we have to have something in place so that there is a rule somewhere of this is what you do when it's time to hand this off to the attorney. And there has to be a penalty of, and if you exceed your scope, what is that penalty going to be? Because yes, it's going to be very tempting. And so I'm not sure how to regulate that, but I see those as very important issues.
I mean, that's probably a competency issue anyway. I mean, if it gets too complicated, even an attorney who does, I've seen this, you know, they may do divorces, but they don't do paternity. So they're not aware of paternity puzzle and what the laws are. And they just file a motion on something that's barred by statute. And remember, family law is not about loss of money necessarily, but it's about the attorney doing the wrong work or paraprofessional doing the wrong work and causing their client to not, get increased contact with their child or lose on a restraining order. So it's more than monetary loss. My thought was that I want to make sure that I definitely I believe in consumer protection. I don't want to come across that I don't think consumers should not be protected. I'm just not sure if, having super expensive bonds or malpractice insurance is the answer necessarily. I just don't want to make it too cost prohibitive for these current LDAs and notarios and paralegals to become licensed and follow the rules to become competent and work under the table. And we all know they will. I mean, there are people who are not going to care about this, okay? And they're not going to be caught. Just like notarios out there, we see them. I mean, nothing happens to them. So I just want to make sure that we make it worth their while and we make this lucrative for these folks to now become licensed so they can become regulated and educated and competent.
Okay, Judge Yu and then Ira.
Thank you. I'll make my comments brief. First, I believe it was Mr. Sandman who made this comment that Fariba referenced regarding at some point a paraprofessional would be referring to an attorney. And then my comment is really about, do we have demographic information for California about the paralegal population and LDAs, and then for the other jurisdictions? Because I want us to hopefully just be mindful of the fact that as we make these regulations and if we require insurance or not, or a cap in fees or not, that we're not going to make rules that entrench already existing systemic disadvantages for women and for minorities. I don't want to assume anything, but from what I've seen anecdotally, there are people who maybe are, maybe more women are doing the paraprofessional LDA, maybe more people who speak other languages are doing that. And I would hate to see any inadvertent, unintended, systemic, racially disadvantaged rules put in place. Thank you.
Ira and then Julie. Ira?
Sorry, yeah, I didn't unmute. First of all, somebody mentioned, one of the speakers, guests mentioned requirement to that paraprofessionals tell their clients about the availability of free services like legal aid and other organizations like that. And I think that ought to be a requirement. Secondly, on malpractice insurance, malpractice insurance and other things we've talked about, saying, well, the attorneys don't have it, therefore paraprofessionals shouldn't have to have it. I think it's the opposite. I think that in writing creating this new group of professionals, that we ought to take a lead in some areas where, at least in my view and many people's view, the state bar rules, the lawyer rules, are not consumer friendly. Many states have required legal malpractice insurance. And for some reason, apparently the most recent reason is we don't know enough about it. The state bar is one reason. We don't have it. And I think it's terrible. I've always thought it's a really terrible thing that we don't have that for lawyers. So as far as malpractice insurance, as far as fee caps, fee maximums, let's take the lead. And maybe once the public learns that these paraprofessionals are required to have insurance, they'll say yes, and so should lawyers. No, that's my last point. Thanks.
Great. Julie and then Stephen.
Thank you. I'm generally in Fariba's camp, in that I don't think we should impose on paraprofessionals stuff that we are not going to impose on lawyers. The problem, though, that I have, and that my former organization that I retired from has, which was the Center for Public Interest Law, is that we think many of the bar's regulatory programs are totally lame. So look at continuing legal education, for example. The number of hours is ridiculous. 25 hours for lawyers every 3-year period. And those hours need not be in any area related to the area of specialty of the attorney. As to paralegal, excuse me, as to paraprofessionals, I would be opposed to requiring more hours than we require from lawyers, but your proposal on page 3 of this document already improves on the MCLE requirement by requiring that the vast majority of those hours be taken in the paraprofessional's practice area. So I would limit it to 25 hours, same as attorneys, but require it to be in the practice area. In terms of financial responsibility, the bond issue, Amos mentioned that a lot of professional licensing boards have a bond requirement, including the contractors board. I will tell you that the contractor's bond is about half of what an LDA has to pay. It is lame also. When a contractor gets in trouble, the subcontractors who haven't been paid by that contractor beat the consumers to the door. So consumers who have been screwed by that contractor, there's nothing left of that bond because it's so small. So I would also be interested in discussing with Elizabeth and the LDA organization and the other organizations that have bond requirements as to whether that is an impediment on their ability to work, and whether it's helpful at all. In terms of client security fund, I don't have a problem with having a client security fund. It's funding it adequately. And currently the CSF in the state bar is not funded adequately. And I would ask your staff, members of this working group should ask bar staff what the cost would be if you expanded the CSF for paraprofessionals to include malpractice in addition to intentional deliberate theft, which is what the current CSF for attorneys is confined to. Finally, on page 6, you talk about mandatory disclosures. I have no problem with that paragraph right there on mandatory disclosures for paraprofessionals. For some reason, I disagree with Ira on the requirement, the additional, somebody mentioned earlier today that we should require paraprofessionals to inform their clients that there are free legal services out there. I don't like that. But I don't mind this mandatory disclosure paragraph, and I pretty much don't mind the informed consent requirement. On fee caps, I don't think there should be fee caps. I agree with Fariba. The market will command the fees that can be charged by these folks. And lawyers don't have fee caps. Lawyers would be horrified if the State Bar ever purported to impose fee caps on lawyers. So I just don't agree with that either. Thank you.
Thanks. Stephen and then Elizabeth.
Which Steve?
Fleischman.
Yeah, just on that last point, Julianne, there are limitations on what lawyers can charge by statute or.
You mean MICRA?
MICRA is one, workers' comp is another. I can look up, but there are more.
Mhm.
I have a question for the staff about the client security fund. My understanding is you have two sources of money for that fund. One comes as a portion of the dues all attorneys pay every year. The other is the interest issue in the client trust account that Carolyn mentioned. And my understanding is that second one, the interest, simply because of interest rates right now, that revenue is at an all-time low. So really the bulk of the money is coming from the attorney dues. Tell me I'm right, tell me I'm wrong. I'm just trying to get factually accurate information.
Yeah, that's incorrect. The
Okay.
only source of funding is the licensing fee. The IOLTA money is going out to legal services organizations. So it's the licensing fee that is supporting the client security fund. And there was statutory authority for the State Bar, or I believe it's ongoing authority to transfer any surplus funding in the lawyer assistance program fund to the client security fund, because the LAP fund did have for many years a very sizable reserve. But the real funding comes from the $40 fee that's levied on attorneys.
Then I would be in favor of paraprofessionals are going to have to pay dues just like lawyers. I'd be in favor of capping it to the same amount lawyers pay each year, and they would have the same $40 requirement lawyers do, and the fund will be, whatever amount that works out to is what will be in the fund. My last point is as to Carolyn about professional liability insurance. Most CGL policies for standard businesses have an exclusion for professional liability. So if you're a trucking company and you get sued for legal malpractice, that's not going to be covered under that policy. The companies you're talking about, like a Walmart that has a large in-house law department, would purchase additional professional liability insurance, either separately or as a rider. But I wouldn't make the assumption that your ordinary business is covered for professional liability, because it generally isn't.
It's a thing, just really quick. It's a thing that when they brought it up in ATILs, that went through my head. I was sitting there going, it's not going to be covered, folks. So it's a conundrum. It's a conundrum. Maybe
But
there's a way.
I'm just telling you, my partner Lisa Parachet was on the legal malpractice State Bar Committee. Mandating legal malpractice insurance for anybody is a quagmire, and our committee should not get into it. I'm in favor of what Amos is saying, that we should encourage it however we want, but mandating malpractice insurance is a quagmire.
I just want to make two quick points here. One is that I'm not opposed to requiring fee caps to the extent that it's required in certain areas for attorneys. I just want to stay away from arbitrariness and always relying on or because you're a paraprofessional, we're gonna have fee caps. Number two, fee caps are really hard to figure out, especially for example, in the area of family law. I mean, it's a lot of work and we may not get it right. And finally, I just wanna say, let's say we require bond and malpractice insurance and fee caps for this paraprofessional, right? The case gets complicated, they refer it to an attorney who may not be competent in that area, but they say they are, who will not have malpractice insurance and who will not be bonded. I just cannot make sense of that. So either we're gonna have to improve our system and make attorneys have to get the same consumer protections, or we're gonna have to look at what we're gonna require of paraprofessionals, how it makes sense. I'm just looking for that rationale there.
Okay, Elizabeth and then Claudia, and then Amos. I think that's the end of the raised hands.
Thanks, yeah. So I just wanted to address the bonding requirement for LDAs. It's a $25,000 bond. It used to cost $395 and you were covered for 2 years. It actually went down in price, so it's only $295 and it covers you for 2 years, and it's a protection for the public. Some of the LDAs think that that $25,000 bond is going to help them with legal fees if there is a claim filed against them. So that's why they act right. But in reality, it's a protection for the public, and we're doing our best at CALDA to inform them who that bond really protects. But the $295 is not an impediment to, becoming a registered legal document assistant. As far as the immigration consultant, their bond is based on credit, just like the one for the LDAs. But immigration consultants registered with the Secretary of State need to be bonded for $150,000. That one is a little more difficult to obtain. Both of them, I believe all you have to do is apply. They run your credit, and then you are approved. With the immigration consultant one, the bond cost can be anywhere between $2,500 to, I've seen it, $8,000. And it also only covers you for 2 years. And again, people are, because of the price that some people charge, for citizenship, like $500 to do citizenship applications, you're able to get the bond money back. You're able to make it so people do become registered immigration consultants. Right now, the NNA, the National Notary Association, is also offering bonds. So I just wanted to answer some of you guys' questions. One thing that hasn't been talked about, and I'm not trying to add, additional barriers to entry, but since I just mentioned the National Notary Association, in order to become a notary in California, you have to pass a fingerprint background check. And so that's something you might want to consider for the paraprofessional position. I don't know that I see it referenced here, but to become a notary and sign off on people's documents, you have to be background checked. Same thing with daycare providers. So just, it's not a requirement for legal document assistance. Now, the application to become a legal document assistant does ask you to disclose, same thing with immigration consultants, to disclose whether you have a judgment against you regarding fraud or misleading the public. And so it's more of a disclosure signed under the penalty of perjury. But those are my, and if anyone has any specific questions, I can answer them.
The background check, Elizabeth, was addressed in the by the licensing subcommittee. I think there was an indication that the paraprofessionals would go through the same moral character process as attorneys go through, and maybe it wasn't explicit, but that does include the fingerprinting.
Thank you.
For that part. Okay, Claudia.
Okay, hello, thank you. So I understand that immigration law is considered federal law, and it's not something that we wanted to include within this scope of this paraprofessional class. I do want to ask that we please use the word notary public when referring to these people that are being called notarios. I'm sensing a lot of cultural bias against this class of practitioners. It is making me feel very uncomfortable. The word notarios implies an inherent predatory intent. It almost sounds like narcos. I strongly feel that we need to use correct language like notary public, because that is the licensing that these people have. A lot of these people are embedded into their communities and are trusted by their people in the communities much more than lawyers. Sometimes lawyers or law students will choose to specialize in immigration law because they see it as a lucrative and reliable source of income. That in itself at times can become a little bit predatory, and the reason that some folks do not trust lawyers. For example, this month, I met a recently retired immigration lawyer who practiced in San Diego for about 20 years. And he told me that you can't walk 2 feet in San Diego without running into an illegal. And that he did really well. And now he's been able to purchase himself a home up there in Washington. It's a beautiful home. He's shown me pictures. So I believe strongly in regulation as a protection for consumers. As you all know, I am not a lawyer. I'm just a citizen. I'm an advocate for myself and the other people who are going to become consumers of this, possibly become paraprofessionals ourselves. But I have heard the word notarios being used derisively several times throughout our meetings, and I feel compelled to say something about that. And if you would all please just refer to them as notary publics. And that would help so much towards building trust, towards building somewhat of a respect, right? A culture of respect. So not really a comment, but a plea.
Thank you, Claudia, for raising that. I agree we should be careful with our language, and I appreciate you raising that to our attention. And I think the term may have not been being used carefully, even with what was intended, because I do think at least some of the public comments as well were about concerns about fraud in the immigration consultant area. And so there are different meanings, different uses. So I agree we should be careful. And I also think this is, again, one of the important reasons why we're talking about regulation and licensing, because I think what we're trying to set up here is something that could earn respect and avoid consumer fraud issues that have been seen to raise really serious concerns on different populations, including immigrant populations. So thank you for those comments. It looks like we have a couple more hands. I think we want to take maybe a 5-minute break, or maybe we'll hear a couple more comments, take a 5-minute break. I think we want to save some time for discipline, as well as 15 or 20 minutes at the end to talk about next steps.
Yeah, we've got 2 more hands and then maybe the break. Steve Fleischman.
Yeah, I mentioned the runner and capper issue and that we heard from the incoming president of the consumer attorneys. I just noticed she's a public participant. Would it be possible to add her to the conversation so everyone could hear from her directly rather than me paraphrasing?
I don't know. We can ask Brady. I'm personally
and I'm not trying to put her on the spot if she doesn't want to.
We don't have that much longer today for the meeting, and we have a number of things to cover, and I don't think there's any decision even begun to be contemplated on that issue. So
yeah, and I'll say for the regulation subcommittee, and we'll have to discuss how this is going to go on for next steps. So we haven't seriously discussed or considered that. I do think it's a critical issue and a complicated issue. So I think probably that's going to be a subcommittee issue for the future.
I defer to you, Amos, how you want to proceed.
Okay, Amos, did you want to just move on?
Are there other hands
up? Greg, there's Greg. Yeah.
I actually will punt as well, because I wanted to bring up referral fees as well. I'm sure perhaps some members of the work group may not realize that lawyers can provide referral fees to each other as long as they comply with Rule 1.5.1. There are some distinctions between those situations, because lawyers can be runners and cappers too under the statute. And there is a distinction between referral fees and one professional referring a case, and there's case law around why that is an important tool for attorneys, especially inexperienced attorneys who may not be able to handle a case. It provides some encouragement for them to not forge ahead and actually refer that case out to an experienced attorney, which benefits the client. But I think perhaps we should just bring that up and talk about that a little bit more in the subgroup before we bring it back.
Yeah, thanks for that, Greg. And I think there's also fee sharing, which is different. And I think we have to consider that paraprofessionals may be working in connection with a law firm or lawyers, and there may be some fee sharing issues too. So I think it's a complicated area that we're going to have to address. If we're done with comments on that, why don't we take a 5-minute break? And I think we are going to have to be mindful of our time when we do the discipline. So we do at least leave 15 minutes or so at the end to talk about next steps, because there are a lot of next steps to consider. Does that work, Leah, for a 5-minute break?
Okay, thank you.
Amos, this is Erica. I'm just sorry, I have a case conference.
It's gonna kick us off.
So I'm gonna kick you off.
Okay.
Ira's gonna jump in as we go along. So Amos, do you want us to go ahead and start?
Yeah, we still have some people missing, but why don't we go ahead and get started? Hopefully,
Okay.
come back.
All right. And we'll try to make it quick as quick as possible as well, in just an interest of time. Ira and I have met several times about the discipline process and what that structure should look like. And in going through it, the first thing we really did was we went through, the state bar and the attorney discipline process, and we actually heard a lot of input from Leah and Greg and Linda on that process. Kind of just went through that step. Then we also talked about, just with my experience and my background, we also went through the DCA licensing boards and their disciplinary processes and what that looks like from the minute a complaint is received all the way in through the adjudicative process through discipline. And then we also were very fortunate that we heard from Mr. Henry from the Washington system as well. And they are in the current process of making changes to their current discipline process. And so it was nice to hear some of the things that they heard and changes that they're going to be making. And so at the end of the day, some of the considerations that we looked at, one thing that was really difficult for us as we first started it, and this is something just for overall and probably for all of us to be looking at in all of our subcommittees, is we really haven't discussed that overarching, and this is in the memo, the regulatory structure for the paraprofessional program. But when we went through the discipline process, one thing that we just assumed that was going to be there was some type of a paraprofessional board. So a board that would be made up of paraprofessionals and public members that would kind of be overseeing this program. And so that was one thing we are making an assumption about in our disciplinary process. Some other considerations that we thought about, obviously cost is one thing that we looked at in trying to identify areas. We know that the state bar process has been stated that it's a costly process. So we did try to look at where we could deviate in those regards as much as possible. But we really wanted to use some of the existing resources also in the initial steps of like that complaint review, the investigation process. But then we also thought it was very important to stray from that somewhat also so we can give that paraprofessional licensee perspective as well. And so that's why you'll see some differences when I walk through the actual document itself. Some questions that we have, we did look at this panel of 3 that I'll also be talking about in a moment. But I do want to give you a little bit of background of why we looked at that panel of 3 versus just one adjudicator. As we started talking about it, one thing we think is really important is that we wanted to eliminate potential bias that may come up, and we know that this is brought up to a lot of regulatory agencies. And so we thought if there was a panel of 3 individuals, you'd have a little bit more dynamic between those individuals and their discussions to kind of eliminate that bias. The one thing we did say is that those individuals, though, should actually be individuals that are static, at least for some term. They would be appointed to that hearing panel, and then they would stay for at least a year, if not longer. And the reason for that really is just to provide consistency. We thought if they were going to be rotating in and out, that they wouldn't be able to provide the consistency that having the same individual would be. And again, we put the board review in there again, just to bring in both public members and also the licensees into reviewing it. Other things considerations that we really thought would be important is that there would have to be some type of a disciplinary rule that really outlines disciplinary consequences for specific violations. So individuals would know what they should be looking at based on what the individual is found to have been in violation of. And so we thought that would be important to have those similar to what you currently have for attorneys, and as well as some type of a diversion program as you're going through the process to where at that point you could be looking at some other type of action in lieu of discipline, or if it was something that would meet that criteria. So with that, I'm just going to start going through the process. Oh, one more thing I did want to mention, I know this came up in public comment, but there was also a discussion about the citation and fine program. And we did talk a lot about that and having some other type of venue that's not currently within the state bar system, but we do believe that that's something that could be there for minor violations as it's going through the process. So with that, just walking through this chart here that you see in front of you, we would, the program would get a complaint, it would come in, and again, this is where we would be utilizing those state bar resources. So those would be going into that OCTC intake step, and they would be looking at it when it first comes in and determining really, and again, that's the Office of the Chief Trial Counsel, that would be coming into that unit, and they would be looking at it at that point to determine whether they should be referring it on for further investigation or whether it needs to be closed at that step. And then if it needs to go on for further investigation, again, at that point, we would still be using the state bar process in that OCTC investigation. And we had some discussion here as to, okay, should we be looking at this at this point, or should we be kicking it to a panel like Washington does to determine the action? And we thought it would be appropriate here at this level to decide what the next step would be after the investigation. So you can see the options there. And again, at this point, all of this would be, again, within the state bar, the current system. And if that gets closed at any point, that individual would be able to request a Supreme Court review of the decision to dismiss or close the case as well. So we wanted to have that appeal rights there for that individual, which is a little bit different from other discipline systems. Once that notice of disciplinary charges has been filed, then this is where it strays from the state bar process. It would either go to, and this is where we want feedback from the group, it would either be a 3-person hearing panel, or we would have just one staff adjudicator that would hear the case and make the decision. But whatever decision that's made by either of those individuals would actually be overseen and reviewed by this paraprofessional board. And at that point, they'd really be looking at what is the appropriate discipline for the action that was taken, and do they agree with the final decision that is written. And then at that point, if either side could appeal it at that point, the individual could appeal it. And if it goes to that appeal, again, we need input, and this is where we wanted input from the group as well, on whether it should be a 3-person panel that reviews that appeal, or whether actually it is just the one staff adjudicator that hears that. And then the where we would also seek help from the state bar side would also be in that prosecution, because the paraprofessional group would be, the program would be basically the prosecution would be done by the OCTC, as well as that first initial appeal. Then at that point, either the board, the paraprofessional board itself, or the licensee themselves, they could appeal that then to the Supreme Court. And I know this was a question I think somebody had, was, is that Supreme Court then the final decision? Yes, then that Supreme Court would be the one that actually is providing that final decision of both either of the appellate individuals who appealed it at that level. And then they would issue that final order. So that's kind of what we have put together as far as the discipline. I know this is like the 30,000 foot level of this discipline process, but this is where we thought you can get both the input from the licensees as well as supported really by some of the state resources of the state bar. Ira, I don't know if you have anything to add as well.
Yeah, just a couple things. The structures is driven in large part by an effort to try and save money in this system. So the boxes in the bottom two rows, the ones in blue, Kim already said this, but those functions are done by employees of the Office of Chief Trial Counsel, which is the state bar attorney discipline body. And considering there'll be far fewer of these paraprofessionals than attorneys, I think there's 200,000 attorneys now. It seems that this would not be a big increase in the expenses or work of the Office of Chief Trial Counsel, OCTC. Then, but then we have hearings. In other words, these are the investigations and charging decisions. Those are the blue boxes. Then, so if there is a charge, then it goes to a hearing. That's the point where we felt to save money, we would not use the state bar's apparatus, which is the state bar court. It was explained to us, well, Leah knows a lot about it, and Linda, that it's quite expensive for the state bar, and also for, it would be expensive for a paraprofessional to be represented by an attorney in that process, I mean, in the state bar court, because it's like a court and it's quite involved like that. So this is where we felt it would be better to set up a process of our own paraprofessional system. And it doesn't involve a lot of people. As you can see, it involves at the first level, the middle box, hearings and settlements, either a 3-person hearing panel or a 1-person adjudicator. Same thing with the appeals from that box, the next box up. Oh, and delay. There's talk that it takes a long time for the state bar court to process a case. And this hopefully would be shorter and a less involved process. I mean, that's the plan. That's the structure. It would be shorter and less involved. And then just to make it clear up here, and remember that one of the attorneys in the state bar told us that in order to, you might not remember, we heard this, in order to be, to comply with the requirement, it's apparently a state constitutional requirement, well, it is a state constitutional requirement that the practice of law be regulated by the Supreme Court. The final, just like in attorney discipline, the final decisions up here, the final decisions of the hearings and settlement, and if there's an appeal, there, the final decisions there would be made by the Supreme Court, issued by the Supreme Court. Not that they would review, reconsider all of them, only the ones that were there on appeal, but all of them they would officially issue. One other thing that you can't see it on the screen here, but it's in our report. We're asking for some feedback on whether we should use a single hearing officer or a single adjudicator or a 3-person panel. And just to make it clear, when it says public member, we got a footnote that you can't see that says that the public members can't be a former attorney. Well, it says former attorney or paraprofessional licensee. Not sure whether attorney is, yes, that's the idea, that they can't be either one, present or former attorney or paraprofessional.
That's for the public members, yes.
Yeah, for the public member. The adjudicator, I had thought that the adjudicator would be a lawyer. Then it was clarified for me that no, not necessarily so. So if
Ira, this is Brady Dewar,
yeah.
Office of General Counsel. I just wanted to clarify, our opinion that we shared was that there's a potential issue and that doing it this way with the Supreme Court would avoid that issue, not necessarily that it's required.
Yeah, I remember that. Thank you. So to avoid a potential problem of not complying with the state constitution. Anyway, I think the adjudicator should be a lawyer. None of the others are going to be. And well, anyway, and especially if it's a person who sits alone as opposed to being on a panel. Okay, I'm done.
And just one last thing, this also would assist with anybody in the paraprofessional licensee being concerned that it was only attorneys that were basically making a decision on their case as well. Because you do have those in their own profession sitting on that paraprofessional board and assisting with that process. And I think that's it. Trying to be as quick as possible through the process.
All right.
Great,
So
thank you.
I see Sharon and then Carolyn.
I have a bunch of questions. I'm not going to ask them all in one shot in order to give other folks a chance to talk. My first question is, did this group consider whether there are going to be criminal remedies or was it just civil that was considered? So that's my first question.
We did not, right, Kim?
I think we talked about it, but we hadn't got into that level, right, Leah? We're not there yet on that process.
No. Do you mean something different, Sharon, than would be applicable in the context?
Yeah, so just I'm wondering about civil, I'm wondering about criminal remedies and what they would be, who would investigate, and what the powers of the investigators would be.
Okay. I guess what I would say is the State Bar regularly makes referrals to the DA's offices for UPL matters. And of course, there still could be UPL in the paraprofessional context. And then other criminal matters, if a paraprofessional breaks the law, just like if an attorney breaks the law, there would be a criminal remedy. So I'm struggling a little bit to understand the nuances of it with respect to this new licensee, but maybe if Kim and I would do that, we take that as something to do.
You know, it just occurred to me, I'm sorry, but real quickly, this is a process for discipline, and it can't be a process for a criminal proceeding, right? That has to be in a court. So I don't know if it could fit into what our subcommittee's charge is.
Well, for example, like, would there be a charge? Like, and would there be a criteria of when you would refer it to the DAs and what that process would look like? Maybe like that piece of it as a start.
Okay.
It seems like that would be something that during the investigation, if they identify that it's a criminal matter as well, that they could refer that to the DA at that point.
Okay. My other question is, I'm still worried about the costs of discipline, and I very much appreciate that the both of you try to reduce the cost by having, you know, this bifurcated system and having like a 3-person hearing panel or having an adjudicator. I still think it's going to cost a lot of money, and I'm just on how much this would cost. Maybe comparing the two options.
I have to confess, we haven't looked into dollars, how much it would cost. Concepts about cost, yes, but not dollars. Or am I right, Leah and Kim?
Yeah.
We could begin to do that, certainly.
Okay, and my final question for now has to do with the public comment earlier on whether minor violations will be part of a public program so that the public can search paraprofessionals. I don't know if this was part of like your purview and whether this was contemplated.
It was contemplated that minor violations would not, well, you know what? It was contemplated they would not be called discipline, and at least in the back of my mind, this wasn't explicit. They would not be public, just like the state bar, similar state bar, minor, whatever it is, isn't public. Maybe the others didn't think that, though.
I don't think that we thoroughly fleshed out all of the public, because again, we're looking at what is that database going to be for these individuals. But I can tell you from experience on our DCA side, citation and fines are public after they have been issued. So that could be something that we would consider that they are actually public and listed in that public website.
Okay, thank you.
Carolyn.
Okay, so yeah, and I think that part of what you guys were just talking about is part of the problem with, and Leah brought it up, this is a hybrid of sorts. At some point, we got to talk about whether we're modifying the unlicensed practice of law, or are we defining the things that a paraprofessional can do. You know, it's a Venn diagram. Where does, and I think again, ATEL struggled with that. There's a couple memos that they have, and Brady gave us a memo on that.
Carolyn, this is one of those things. I'm sorry, I'm interrupting, but this is not the rules that the discipline rules that paraprofessionals would have to follow. This is just procedure for disciplining them, regardless of what the rules are.
Okay, all right. Well, okay, I you know, that I didn't understand. Okay, and I think I'm going to pander to Donna and Leah a little bit. In the report, it was suggested that the state bar program is behind and expensive, but you guys should just ask for more funding on your end. You know, get that. The state bar should be asking for more funding just to get, you know, what you're doing done. But okay, so back to serious things. I understand that there were members of different professional responsibility committees. I don't know if COPRAC, but some of the Bar Association professional responsibility committees were consulted in this. They're not in the report. I'm not sure why. But I think it would be good to go out, make outreach. I don't know. Is COPRAC, the State Bar Professional Responsibility Committee, going to have a chance to look at this and comment on it?
Well, they wouldn't have anything to do with the system. But they would have, they would be valuable to consult by another subcommittee the one that's going to develop the, whoever it is, that's going to develop the rules, the ethics rules, the rules of professional conduct for paraprofessionals. I thought that was the last.
We haven't even started. We haven't even started the ethics discussion.
That's right.
Really.
So that's where the COPRAC members would be valuable to consult.
Okay. Then
staff who work with them.
Okay. Then with regard to I think Judge Yu said something about people of color, making sure, and women, making sure we are monitoring what's going on with them. I believe there was, and again, no offense to Donna or Leah, there was a report suggesting that the state bar actually prosecutes more people of color than, in percentage-wise, not a huge percentage, but it is a percentage than other people. And so there is, a need to maybe look at that bias and track that information. I'm hoping as the disciplinary process goes through, and I think the state bar is working on looking at that issue as well. And then, why didn't we look at a situation, and again, if this is outside your purview, let me know. But again, county, in asking for, before you go into complaints and when there's a situation where there's a dispute, usually you have mandatory fee arbitration for lawyers. We have to give notice of a mandatory fee arbitration. Maybe it's not related. Is that outside your purview and maybe should set something in licensing?
No, we actually did talk about that there would be some type of process for them as well, and but we just didn't have it in here. Right, Leah, we talked about that there would be, we have to look at that arbitration of the upfront process, similar to what the attorneys have.
Okay.
Yeah.
Although I have to say that it to some extent, it's not a good analogy. When you have fee arbitration, it's a money dispute, and it's between, obviously between lawyer and client, and there's not necessary, in fact, there's no disciplinary issue involved in the fee.
Yeah, and some of this
side, so I don't think it fits.
Okay, then just two other comments. One is that in there you mentioned the LAP, the California Lawyer LAP. The LAP is now being carved out and set, and I don't think it's really decided on how that's going to look, or at least I haven't seen that. I haven't really gone back to study it, but my understanding is that the funding for the LAP is not going to be, and the LAP operation is not going to be part of the state bar anymore. So that might be something to keep in mind. And maybe Leah or Linda can kind of update the disciplinary process so that at the end of the day, whatever we end up with understands that if people have substance abuse and alcohol abuse problems, there won't necessarily be a tie-in to LAP. Maybe there will. I know that process is in flux. And then the last thing is, you asked specifically about adjudicators. And in thinking through this, it occurred to me really quickly, aren't some of those adjudicators, could they or should they or must they be ALJs? If they're not going to be full-on judges hired by the state bar, if they're going to be through the Department of Consumer Affairs, do they actually need to, and maybe that solves your problem, they need to be administrative law judges, and the administrative law regulations and that kind of thing will apply to them.
So these would not be an administrative law judge, and they also would not be through the Department of Consumer Affairs. They would actually be through the state bar. Those staff adjudicators would be from state bar.
Kim, I don't know if it's just me, but I'm having a really hard time.
Sorry, it's probably a man.
Yeah. Okay.
Be safe. Be safe.
They would actually be through the state bar.
Okay. Okay, that answers my questions, folks. Thank you.
Okay, and for our time check, it's 3:38. We have one other hand up, which is Steve Fleischman. So maybe, Amos, we can hear from Steve and then move on to our next steps discussion. Is that okay?
Yeah. My question is solely directed to the staff. And I know you can't get into dollars and cents, but explain to me why creating a new system is cheaper and more efficient than simply using the existing state bar disciplinary system. I was very surprised to hear that, because my instinct is creating something new will cost more money than using something existing.
Yeah, I think that's the case on the OCTC, the prosecutorial side, which is why this really does leverage OCTC. OCTC has a UPL unit now, for example, a specialized unit could replicate and create a new unit for this program. But on State Bar Court, the marginal costs are extremely high. When you look at the number of cases that are filed in court versus the cost, even an incremental addition to the number of cases flowing through State Bar Court will increase the cost. And it also does increase the stakes and costs for the professional quite significantly, because they're having to litigate a case in court, and the State Bar Court rules of procedure are they're tough. So that's why this sort of is a hybrid approach that does take advantage of economies of scale on the prosecutorial side, but does something different on the adjudicative side.
But the money spent, the additional money spent creating the new program, if that money was spent on the existing system, wouldn't, I mean, that's what I'm trying to compare.
Yeah, and we haven't done the analysis. There are other policy changes that policy considerations for some of the recommendations that Kim and Ira have come up with. So I think it's a fair point, and certainly on my, my notes to myself is we've got to start doing analysis. But if you wholly replicate the attorney discipline system, it kind of goes to Julie's comment that a lot of what we have may not be optimal on the attorney side. So there you don't have if you did it, you wouldn't have the ability to involve a paraprofessional. You wouldn't have the ability to do some of these things that are contemplated. So I think it's a mixture of cost and policy. And
I'm all in favor of doing whatever the State Bar can to improve the disciplinary system if that's an issue. But we're tight on time. I'm looking forward to hearing your next level analysis on that.
Okay.
Here, here.
All right.
Can I just address one comment that Carolyn said, and that is talking about that report, the bias report that you were mentioning. We did take that into consideration, which is why you have the 3-person hearing panel versus the 1 adjudicator, because that's where we thought, if there was that issue coming in, if you have 3 individuals versus 1, that would be the difference, possibly where that could be looked at from that perspective.
Thank you. Thank you. That's awesome.
Okay,
I get
so-
it. I get it. I get it now. I get it now. I like it.
Okay.
So I think now we can move on to the last part, which is the review update of project plan. But I also think that that's going to include next steps for these subcommittees. Is that right?
Right. Well, I think you all are probably going to soundly reject our recommendation. So we have a staff recommendation, which I don't think actually makes sense anymore. So let's go through this and then. So this slide is simply what we said we were going to do originally, just between now and December. I don't know if you included the additional months in a subsequent slide, Linda. Yeah. So this is kind of everything we need to do. You guys have the PowerPoint. We're not following this schedule anymore. So with that, let's move forward. Here's what we've done. And as we were discussing before, only collateral criminal has had that deep dive, the real decisions about subtopics and tasks. Other areas have gone through that initial cut and the initial level of review. And then we moved into licensing, regulation, and discipline in large part because you all were feeling like you couldn't make any further progress on subtopics or practice areas without understanding the overall licensing, regulatory, and discipline scheme. So go forward. This is all the stuff we still need to do. It's a lot. So move forward, Linda. We were suggesting, so we thought that licensing and discipline could, during the month of November, incorporate any feedback received today I under anticipated or underappreciated how much work there was going to continue to be for those subcommittees. So I thought the regulation subcommittee would work all the way up through the December meeting. That's the difference between November and December, is the idea that there wouldn't need to be that many more meetings of licensing and discipline, which I think is probably incorrect. The regulation subcommittee would hone in on finalizing the financial responsibility piece and proactive regulation between now and the December meeting. And then we thought the family law subcommittee could come back because it stopped midway and we could get through family law. So then at the December meeting, what we would do under this scenario is we consider practice areas and subtopics in family law and tasks. And we'd have an actual sort of recommendation on financial responsibility and proactive regulation. Maybe not a recommendation, but an update, additional update. And then if you could go forward, Linda. And then the big issue that we really feel is a challenge is the revisions to the rules and statutes. Rules and statutes came up in every one of the subcommittees, licensing, regulation, and discipline. The work is informed in part by what you all decide are going to be the authorized practice areas and tasks. So it's a little bit of a chicken and the egg, but not all rules are, but some of them are. There's two components. There's the policy part of the rules, and there's the actual drafting. The policy is most important, but of course drafting is where things get the real work gets done. But the policy, like, are we going to allow referral fees or not? It's a policy question. Then you get into the drafting, and this could be a huge undertaking, and I say significant, possible, potentially, because some jurisdictions like Arizona have simply written paraprofessionals into the rules of attorney professional conduct, adding the word paraprofessional everywhere where it says attorney. Doing that is not necessarily a huge undertaking. So it's potentially a huge undertaking. So questions we have for you are timing. When should we actually get started on this? Should it be a separate subcommittee? Should licensing, regulation, and discipline all tackle the rules with respect to their areas? Should we have a policy group looking at policy separate from a drafting group? So that's kind of a jumble of thoughts. We have this sort of specific thoughts about what we could do between now and December, which again, I think probably doesn't make sense given what we've heard today. And then we have this question for you all to decide how and when you want to start tackling the rules, because I think we need to do that. So with that, I see Steve has his hand up. I don't know if you want to speak. Okay, and then Carolyn, Amos, however you want to handle this discussion.
Yeah, let's go ahead and for people who have their hands raised, go through them and I'll raise my hand.
Am I up?
Yeah.
All right, could you go back a few slides? I'll tell you when to stop.
Linda, I'm not controlling the slides.
Well, I'll just make the point.
Okay.
Brought up family law needs to still continue its work. The same is true for consumer debt and general civil. We're not done with our work. Whether you want to do that between now and December or after December, I'm kind of ambivalent on, but I kind of would, personally, I kind of would like to get back to work and narrow those topics.
So your kind of vote is to go back to practice areas?
Yes.
Okay. Carolyn.
You're muted, Carolyn.
Sorry. Okay, I like that. And what I would just add on to, I have 2 points. I would like that, and I would add on to that, what we're doing is shaving. I think there's, shaping and shaving on those issues, because some of them will have to deal with regulations in their own fields and their own right. And this may be a 2 meeting, this may be December and February kind of thing that we have to think through, because we, like as Steve said, we really need to know those areas But with that being said, I think there's some parts of the licensing and the discipline that maybe can go to other professionals a little bit more detailed. I think that discipline function within the state bar, that's probably more easier for people to tackle and figure out how to write the state bar procedures. And it may be something outside all of our ken. Nobody here may understand that, the people who wrote the report. So that might be something that we could do. You could go to a drafting committee on, I'm wondering. So I'd like to hear everybody else's thoughts on that, on these things.
All right, we have Fariba and Sharon.
So I agree. I was one of the ones, I'm on family law, and I was one of the ones that I just didn't feel like discussing practice areas without first talking about licensing and regulatory and so on. Now that we've had this sort of report from every subcommittee, including mine, I think I'm ready to go back and do the work simultaneously. Ms. and I need to meet with you guys and to do more work on our subcommittee, but I'm also ready to go back to the meeting with the subject matter area and kind of taking that up again and just working side by side.
Okay, Sharon.
Actually, my comment was very similar to Fariba's. I'm also wondering, in addition to the substantive areas that are still looming, like family law, is there going to be an opportunity to go back to the other substantive areas like housing to discuss more of the nexus between licensing and those areas?
Yeah, we need to go back. So we don't have, we've not done the further review of housing at all. So we need to go back to housing. We don't have the list here. And Carolyn, I appreciate your asking for it. I think we should start planning to include that for every meeting, just so we can keep track of where we are. But the answer is yes, Sharon. There's consumer debt, there's housing. And, I don't think we as a staff team, and really you all, because there's not that many of you and several of you end up being on more than one committee, we can't do it all at once. We do have to pick and choose a little bit what we're going to tackle. So I just want to say that. So that's why, we recommended just picking one substantive area if we were also going to continue with regulation, licensing, and discipline in any capacity between now and December. And if we're not, then we could do a couple of substantive areas. I would suggest there should be at least one more meeting of the licensing, regulation, and discipline, just to reconvene after all this comment you got today and document what the next steps need to be when you turn back to it.
And I acknowledge that some of these substantive area conversations seem like they happened a lifetime ago.
Yeah. All right, Ira, then Julia, and then I'm going to turn it to you, Amos. Kind of.
I don't have a handle on this, but is there do we have enough people, resources to go forward with the substantive areas and also with these, if you will, procedural areas, discipline and licensing and all that at the same time? And one thing I want to say about it is, as far as the rules, the professional conduct rules, it sure seems to me that we could, there's a strong likelihood we could just adapt the current lawyer rules, the rules of professional conduct. If other states can do that, and I think 2 have, right? And everybody, all the states' ethics rules are pretty much the same. If other states can do it, it sure seems to me like we can. And there's so many advantages besides the ease of doing it that these rules have been interpreted for years. All right, anyway, you get the point.
Yeah, and the very last slide, which we didn't go through, is just a little snippet for all of you. Fariba and Amos had the benefit of seeing this, but our Office of Professional Conduct, just the amazing team there, already went through all of the rules and did this sort of crosswalk to say, would this be applicable to a California paraprofessional, or yes, if adapted, or no, they didn't, just in their opinion. So there's a lot of groundwork that's been laid in that regard. Julia.
I would love to see that also, if we could see that just once it's available, if it's in Dropbox.
Yeah.
So I would say, yes, I think it's a good idea that we reconvene with our groups at least one time following this meeting, since we received several questions that I don't think Steve and I expected. And I think in advance, I already know a couple things that I would propose for that meeting, and it would be more information from the master's programs that was talked about today, and the other law schools that we had not previously included. So I would like that information to be available at that next meeting. And then I think too that we should return after that to the substantive meetings. And I think if subcommittees finally get to the point of what's the next place they can go to with what they have regarding the subject matters, then they should be able to continue to work. I know that Steve and I felt we needed more information about the true scope before we can do more with curriculum and those kind of parts of licensing. But I'm very agreeable to at least one more meeting with Stephen in November to reflect on what we heard today. And I would like that additional information that was raised and interested so many people in this meeting today.
Okay, Amos, that's the last of the speakers. How do you want to proceed?
So I think I'll just make a comment and maybe invite a motion on how to proceed. I think my overview of what was just said is that we have a lot of work to do. It's possible, I suppose, that we're going to move forward on everything at once, but that may be really challenging given the size of our group and what that would require of bar staff. So we may want to pick and choose. I think we have some momentum going on these issues on licensing, regulation, and discipline that I think we should follow up. I think regulation in particular has a lot of work to do still, and we might want to invite more members to that, have more public comments on that, because we have a lot of work. So I hesitate to open everything up, but I also hear a lot of feeling that we should go back to identifying practice areas and practice groups. So maybe I'll just invite a motion on really what we should be doing next in preparation for our next full working group, which is in November. Is that right?
Yeah, well, it's in December. We haven't scheduled it yet. We need to.
It'll be in December.
I don't know that we need a formal motion. Can we just have somebody put forward their idea? And I don't know if these folks raising their hands want to do that. Julie, Sharon, or Greg?
No, I don't want to do that. I just want to know, do we have this PowerPoint? Do we have this PowerPoint somewhere?
I believe Linda sent it out.
Okay, I haven't come across it, so I'll look for that. Thanks.
Okay, Sharon?
And actually, my question is based on what Amos just said, which is there an opportunity to expand these groups beyond 2 groups? Because it's not that I want to be a meeting factory or prolong the process, but I think that there's also an opportunity to maybe divide and conquer on some of these next steps.
I think at least for regulation, it could be very helpful to get other people added and more public comments with regulation, because and we probably will still have some split recommendations, but I think more discussion at the subcommittee level would be helpful. I don't know how other people feel about their committees.
Oh, I haven't raised my hand, sorry, but I remember a discussion when we formed these committees of, I think it's of 2, was to be able to have discussions without having to post agendas and things like that. Am I recalling that wrong?
Yeah, so it's just that the meetings will need to be noticed 10 days in advance. And what I would say is, if we are going to go that route, I think we probably
well, we could have a December meeting, but if we have a December meeting, I really don't think there's going to be any recommendations brought forward. It would be a continued kind of progress reporting. Because if you think about having to notice meetings 10 days in advance, just thinking about the logistics of it, it's very difficult to schedule. So that's all.
So at least for regulation, I'd recommend that we do that and just get some calendar, some dates that work for the subcommittee and try to move it forward. But again, I'm open. I don't know if that's the same for other committees. So do we have anyone to suggest how we proceed?
This is Carolyn.
And Ira have their hands up.
Yeah, just in the scheduling vein, I was thinking that these would be at the end of the month. I have scheduled vacation time, Your Honor, that goes from December 8th, the Wednesday, I think, to the end of the 19th, all that next week. I will be completely out of touch, out of the civilization. So those days, I am not totally on electric. So anything that happens between then and then.
Yeah, it just may not be realistic. We may need to look at a January date. I do want us to have a meeting in part because you are slated to give an update to the board on your progress at the board's January planning session, which I believe is the 3rd week of January. So we're going to need to make sure we get together in time to figure out what you want to say. But December just may not be realistic. Ira or Greg, thoughts? Go Ira and then Greg.
All right. Hate to say this because of anyway, we had at least 3 people, members of the public, and say, gee, we really want all the meetings to be public. And I'm in favor of that, despite I really appreciate the difficulty of having the 10 days and following all the rules for the Open Meetings Act, but still I think we should do it.
I second that. Not that it's a motion.
Greg, and then for Reba, we are going to have to wrap this meeting up. Greg.
Yeah, I'll be quick. My comment just pertains to the rules. We just actually went through a 3-year process of revising these rules, and the court adopted them in 2018. There's an advantage there, I think, for this group in that a lot of the public policies underlying these rules have been vetted and approved by the court. It's hard for me to imagine a lot of these rules need to be changed based on the scope of practice that we approve for these paraprofessionals. We purposely, when we drafted these rules, made them as generally applicable as possible to lawyers practicing in any kind of area. And so my only comment is that I don't think that diving into these rules, and maybe it's something that staff can do first, and I'm happy to help with Randy and the group, in the professional responsibility group, and actually just taking a crack at drafting them and then bringing them back to the group, because it seems daunting, but at the same time, a lot of this work and a lot of the thinking has been done very recently. And so where there may be particular rules that somehow need to apply to lawyers differently than the paraprofessional, I think we'd be able to highlight those quickly. But for the most part, I would think that most of these could apply to a paraprofessional.
Okay.
Can I just add to what Greg said? The process of revising the rules, 3 years, you're being kind, Greg. As I recall, there were multiple attempts. And I feel very comfortable adopting what you're suggesting, which is starting from the rules. These rules were vetted more than anything else I've ever seen.
Yeah, I concur.
I mean, Greg, if I'm wrong, tell me, but I recall there were multiple proposals and the Supreme Court kicked it back a few times.
There was, and in the last iteration, the second commission, I think one of the reasons it worked well was because the court was involved from the beginning.
Okay.
So Amos, just to move us forward, I'm thinking what I'm hearing is licensing, regulation, and discipline are all going to continue. They're going to be, membership is going to be opened up to other members of the working group.
So we'll need to do some kind of solicitation to find out who wants to participate. And I think regardless, maybe no one else wants to participate, but the meetings will be publicly noticed, and so that we can address that problem. And there is also a desire to move forward with some of the remaining practice areas. We can't do all of them. So just from a staff capacity. So I think that's what I'm hearing. Does that sound accurate?
That sounds right to me. And I do think the staff recommendations of starting with family law makes a lot of sense. I think there was a lot of progress and that was sort of stopped. So I don't know who is on that committee, but would that committee be agreeable to be one that goes forward along with the 3 other subcommittees, the licensing, regulation, and discipline?
I'm on it and I'm fine. I think Steve is on it with me. I just wanted to ask Leah, you said earlier that, if we increase the size of the subcommittee groups, which by the way, I think will be helpful, at least for us. You said something about if we meet in December, we're not gonna come up with recommendations, but just a progress report.
Well, I don't know. I could be being overly pessimistic. I just, it has been hard in the past to work with these larger working groups and get things done in a very timely fashion. And it's already October 29th. The end of December is Christmas. So we're looking at a very there's not a tons of time. So I could be totally wrong. We could have recommendations for December. We may not.
And I think it's
I'm available if anybody needs
on how many people want to be on this subcommittee. It will depend on that.
Okay, so my suggestion is we do this exactly as you said, Leah, with the 3 subcommittees and add family law. I don't know if anyone has a strong feeling if any other committees should be meeting between now and the end of the year as well, but I think that is a lot. And maybe will be a lot of.
I would add consumer debt.
Can we have a signal of reminding us of what all committees we were on?
Yeah, we need to do that. I myself am going to need to hop off of this call. So I think we are going to have to finish this up by email. We will send out what subcommittees folks are on. I heard your ask on consumer debt. I just don't personally believe that we as a staff team have the capacity to staff 5 subcommittees. So I do think we need to pick one right now. I'm happy for it to be consumer debt, but I just want to be straightforward about that because it's a lot of work.
If you would like someone to make a motion, I'll make a motion that I think it should be family law, since that is the model that we're using to progress with our licensing. I would like to have a meeting in November with Stephen. And if later others decide they want to join and make them public meetings, that's fine. Otherwise, I would just like one additional meeting with Stephen to process what we heard today and whether or not it changes any of our considerations. So the motion is for the 3 subcommittees that have been meeting to date, have them meet again in November to reflect upon what we learned today. And I am fine with the only other subcommittee going forward as family law. And I think it would be of great assistance to us.
If there can only be one substantive law committee meeting next month, I'm fine with what Julia just said. I agree family law is more important. I just don't want consumer debt to be left out. So having said that, I'll second Julia's motion.
Thank you, Steve.
Okay. And what we'll do is we'll email members of the working group to see who wants to be added to which subcommittee. And I understand, Julia, you want one meeting without those additional people, and that's fine.
Thank you.
Okay.
Great. It sounds like we have a way forward, and thank you, everyone. That was a great meeting. I think it was a lot of progress.
Yeah, thank you.
All
right.
Thanks, everyone.
Bye.
Thank you.
Have a great weekend.